So good morning, everyone, and welcome to the 2017 Samuel Dash Conference on Human Rights, which this year is being co-sponsored by the Human Rights Institute and the Georgetown Journal of International Law. My name is Andy Schoenholtz, and I am the director of the Georgetown Law Human Rights Institute. I also co-direct the CALS, the Asylum Clinic on campus. At the Institute, we're simply thrilled that you've joined us for a full day of conversation about the critically important work being done by lawyers and advocates to address and redress violations of human rights and international criminal law. I'm very happy that we'll be joined during today's program by a number of my Law Center colleagues, including Professors Jane Stromseth and David Luban, as well as Dean Bill Traynor. As always, the engagement of the Georgetown community in this conference each year is a testament to Sam Dash's lasting impact on us all. Before we begin today, I want to take a moment to specially thank Professor Stromseth, who is most responsible for bringing these amazing experts together in one place. That's quite an achievement, as I was learning this morning, to get all these extraordinary experts together. We're very lucky at Georgetown to have Jane back on campus after she spent 2 years with the State Department, which you'll hear more about later this morning. And this year's fabulous agenda simply could not have happened without all of her tireless efforts. So thank you again, Jane. As many of you know, the DASH Conference is an annual event by the Human Rights Institute held in honor of Professor Sam Dash, who was a cherished member of our faculty for nearly 4 decades. Professor Dash's family, friends, students, and colleagues created this conference in his memory after he passed away in 2004. And each year we've gathered to remember his important legacy and focus on the human rights issues that were so important to him. More about Professor Dash's career and his impact on the law can be found in your programs and some of the items on display in the back today. In addition to teaching at Georgetown between 1965 and 2004, he served on the board of the International League for Human Rights and traveled widely to pursue justice. Perhaps best known for his role as chief counsel of the Senate Watergate Committee, Professor Dash pressed for justice and accountability at home and abroad and led human rights missions among various places to Northern Ireland, the Soviet Union, and Chile. In 1985, he became the first American to visit Nelson Mandela in prison and participated in the negotiations that led to Mandela's release. We're also thankful to be joined by some of Professor Dash's family who are here today. We regret that for the moment I don't see Judy Dash, his daughter, who hoped to be here today. I'm afraid she actually broke her ankle and it's given her problems, so she may or may not get here today, but we're very grateful that Rachel and Judy and the rest of the Dash family have been so supportive of the Dash Conference all these years and are very valued members of the Georgetown community. There are countless scholars, lawyers, and human rights defenders who followed in Professor Dash's footsteps, and we continue to be grateful for the family's contribution to the Law Center and the broader legal community. Today's conference was only possible because of help from so many here at the Law Center. As noted before, Jane Stromseth deserves all our thanks for conceptualizing and organizing today's discussions. We also had help from one of our law students, Lisa Passarella, who's here helping us again today. And as always, the Dash Muse fellow, Patrick Griffith, who's in the back of the room and has done his magic in so many ways. An event like this takes a lot of coordination with a number of offices of the Law Center to make it run smoothly. The Office of Special Events, especially Deb Gates, catering, facilities, and AV, the staff here always makes time for the Dash Conference, and we're very grateful. Finally, we want to especially thank all of the experts who are here in the audience and on the stage right now who've taken time to join us here today. Chief Justice Jallow is joining us all the way from the Gambia and will be arriving in a little bit. And we are very lucky to have him and so many important, very busy experts who've come to share their expertise with us here today. Before we get started with today's program, I want to provide a bit of context as to why the Human Rights Institute was so excited when Jane proposed the concept for this year's DASH conference. International criminal law and efforts to hold violators accountable are the kinds of real-world issues that Georgetown is so well placed to highlight. We have multiple faculty members who are expert in the area, and you will hear from a number of them today. Our students study and have worked with some of the courts and tribunals that we will highlight throughout our program, and the policy process that often influences the effectiveness of accountability efforts, which operates at the intersection of international criminal and human rights law, is affected by decision makers who are located right here in Washington. There has been so much in the news in recent days and months that lead us to reflect upon the past, the present, and future efforts to address accountability for atrocity crimes. South Africa's ongoing attempts to withdraw from the International Criminal Court, following the government's refusal to arrest the indicted Sudanese President Omar al-Bashir last year, have sent shockwaves through the international human rights community and left some concerned about the future of the court. However, the decision by the Gambia's newly elected, democratically elected government to embrace the Rome Statute stands in stark contrast to attempts by others to delegitimize the court. The fact that the Gambia has now appointed such a prominent former war crimes prosecutor as Chief Justice sends a strong message about that commitment. Similarly, daily reports of atrocities in Syria have led some to question the prospects of accountability in the future. But as we speak, scholars and advocates are developing new strategies for ensuring that if the international community has the will to hold the Assad regime accountable, it will have the resources it needs. Our discussions will touch on these and many more topics of critical importance to victims and their advocates around the world. We will begin with a discussion, perhaps more timely now than we could have imagined when we began organizing this conference, about the role of the State Department's Office of Global Criminal Justice and Office of War Crimes Issues, which will be moderated by our very own Jane Stromseth, who, in addition to teaching here at Georgetown, has served as the deputy to the Ambassador-at-Large in the Office of Global Criminal Justice. After a brief break for coffee, which is always available in the back of the room, Professor David Luban will moderate a discussion on the ICC's role in global criminal justice and an evaluation of the court's accomplishments, impact, legitimacy, and the challenges it faces. During lunch, we will hear a keynote address from Chief Justice Hassan Jallow, who is not only the Chief Justice of the Gambia, but also the former Chief Prosecutor of both the International Criminal Tribunal of Rwanda and the UN Mechanism for International Criminal Tribunals. Dean Traynor will introduce the Chief Justice, and you'll hear much more about his incredibly important work then. Finally, we will explore innovative models of justice, capacity building, and empowerment through a panel moderated by our colleague from the Ben Ferencz International Justice Initiative at the U.S. Holocaust Museum and former principal deputy in the Office of Global Criminal Justice, Anna Cave. The discussion will focus on the range of domestically based and hybrid courts, as well as efforts to document atrocities, build capacity, empower, and engage more effectively with the directly affected communities. Following the formal program, we hope you will all join us for a reception here from about 4 o'clock to 5 o'clock so that we can continue what promises to be an engaging day of discussions. One housekeeping note. I want to make sure everybody is aware that today's very important discussions are being recorded and will be available on the Human Rights Institute's website. So please know that today's conversations are on the record. With that, I'll turn the program over to Jane and our first panel on the U.S. role and accountability for international atrocity crimes. Jane?
Great. So first of all, I'd like to thank Andy for your very kind and generous remarks and for your strong support in making this gathering possible. Special thanks also to the Dash family and to Patrick Griffith, the fellow of the Human Rights Institute, who's worked tirelessly, and to many others who've done so much to bring us together. I'd like to welcome you to the first panel. I'm Professor Jane Strumseth, and I'm delighted to see so many of you here, so many friends and colleagues. And I'm also excited and would like to warmly welcome those who are listening through our webcast. Our panel this morning will focus on the U.S. role in advancing justice and accountability for international atrocity crimes. American leadership was critical in establishing the Nuremberg and Tokyo tribunals after World War II and in contributing to the development of international humanitarian law. U.S. support through the UN Security Council in the 1990s was crucial in establishing the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. And the U.S. also has supported creation of numerous hybrid tribunals, including the Special Court for Sierra Leone, the extraordinary chambers in the courts of Cambodia, just to name a few. And these are courts that combine national and international judges, prosecutors, investigators, defense counsel, and administrators, and that seek to hold to account perpetrators of genocide, crimes against humanity, and war crimes in fair and impartial trials. At the same time, as you'll hear in our panel today, the U.S. has had a complicated relationship with the International Criminal Court. Although the U.S. is not a state party to the court, the U.S. has particularly in recent years engaged pragmatically and constructively with the court, supporting its work in a number of ways and continuing to support innovative domestic and hybrid accountability mechanisms that are complementary to the ICC. And for 2 decades now, since 1997, America's role in advancing justice and accountability for atrocity crimes has been shaped by ambassadorial level leadership and a dedicated small but mighty team of experts at the U.S. Department of State. And we are so fortunate to have with us today leaders of that office, which was first called the Office of War Crimes Issues, or SWCI, created 20 years ago, which was renamed the Office of Global Criminal Justice in January 2012. And our panelists today include Diane Orndlicker, Professor of Law at American University and former Deputy to the Ambassador at Large in the Office of War Crimes Issues, Stephen Rapp, Distinguished Fellow at the U.S. Holocaust Memorial Museum and the Hague Institute for Global Justice and former Ambassador at Large in the Office of Global Criminal Justice and former Chief Prosecutor of the Special Court for Sierra Leone. David Sheffer, Mayor Brown Hellman Professor of Law and Director of the Center for Human Rights at Northwestern University and the first Ambassador at Large for War Crimes Issues. And Clint Williamson, Professor of Practice at the Sandra Day O'Connor School of Law at Arizona State University, Senior Director for Rule of Law, Governance and Security at the McCain Institute, and former Ambassador at Large for War Crimes Issues. Their full bios, which are very impressive, are in the program. So I'd like to, at this point, delve right into our discussion by asking some questions of each of our distinguished panelists. And our format will be interactive. I will save plenty of time for Q&A with the audience toward the end. And finally, let me just add a personal note. Having served in the small but mighty Office of Global Criminal Justice, and I'm delighted to see so many former colleagues here today, as Deputy to Ambassador Rapp, following in the capable footsteps of Professor Diane Orndlicker and Professor Beth Van Schaak, I'm especially delighted to moderate this discussion today. So let me start with a question for Ambassador David Sheffer. David, you have been for so many years a prominent leader on justice issues, including as the U.S. chief negotiator at the Rome Conference that led to creation of the International Criminal Court, and as the very first ambassador at large for war crimes issues, a position established in 1997 during the Clinton administration. So I'm wondering if you could explain a bit about what led to creating a dedicated office at the State Department led by an ambassador, and how having such an office was important to American leadership in advancing justice and accountability.
Thanks very much, Professor Stromseth, and thank you very much for this conference. You know, when I was a student here at Georgetown Law, I actually audited Sam Dash's criminal law course. I didn't need to take it for my degree, but I audited it because it was Sam Dash. How could you possibly not audit his class? And when I came here as a visiting professor to teach in 2003, I remember that he brought together all the new professors on campus for a discussion about how to teach law. So of course I went, and I still to this day use a particular technique that he advised me of at that particular session when I teach. So I'm doubly indebted to Sam Dash, and I'm very proud to be here. Well, you asked, obviously, about how this all came to be. The idea for an ambassadorship and then an office, obviously, to support that ambassador at large, a functional ambassadorship, not a regional one. People who see me as ambassador always ask, well, what was your embassy? And I said, well, an office on the 7th floor of the State Department. I didn't get a residence. Nonetheless, the idea started to germinate in about the third year of the first term of the Clinton administration, which would have been about 1995, when the workload that I had as senior advisor and counsel to Dr. Albright, who of course was the U.S. permanent representative to the United Nations, she had delegated the war crimes brief to me. And of course, she had a lot of war crimes work erupting at the United Nations, first with the former Yugoslavia and then with Rwanda. Somebody at the staff level, of course, had to deal with that, and that became my responsibility. And I was in the Washington office of the ambassador, so I also attended all the National Security Council meetings and was deeply involved as deputy in those meetings with what was transpiring in the former Yugoslavia and Rwanda. So this just became an overwhelming agenda of work, and I started to talk with her about the need for a special envoy. We called it special envoy in the early days of discussing the issue. And we actually ran that by my very good friend John Shattuck in DRL, which is Human Rights, Democracy, and Labor. And of course, I was a little bit turf poaching, which in the State Department is a very risky thing to do. John was very respectful and said, Dave, sounds like a great idea. Let's move on to the next subject. And so it sort of festered, but, you know, John and I were extremely good and close in terms of pursuing these issues, along with the Legal Advisor's Office. When Dr. Albright became Secretary of State, of course, that was the critical turning point, because then she had the authority to bring this issue to the president for his approval. However, there's one anecdote I must tell you. Before she did so, we were in the transition office for Secretary of State at that point, and she asked me, David, would you like to be ambassador to the Netherlands? Because there you could take all the war crimes work closely with the tribunals, and just become sort of our outpost for war crimes work. And so I said, well, yes, I'll pursue, yes, of course. And 3 days later, she called me back in and said, Dave, I don't think the Netherlands will work out, because our existing ambassador there, who's very, very good, wishes to stay another year, and therefore we need to accommodate that request, and you can just stay on as senior advisor to the Secretary of State until we have a chance to actually get you to the Netherlands, or we could pursue some other idea. And so she said, do you have another idea? And I said, well, we've been discussing this for a couple of years. Why don't we create an ambassadorship for war crimes issues? And she picked up immediately on that, because we had been talking about it. And that was the beginning of the idea. She took it to the White House. The president approved immediately the proposal. And then we started the long journey to confirmation, which was not really that long. I'll just tell you, for this particular position, the toughest thing was getting by White House counsel in order to get your file over to the Senate. Once it was at the Senate, it was easy because we had dealt with all the issues before getting to the Senate. And so then it was created, and I needed a staff, but I had no budget. Which is typical. And so I had to take secondments. I had to pull Foreign Service officers in or secondments from the Pentagon, et cetera. And then as of August 1997, we began to build the office. I thought it was important to immediately get out in the field, so I spent the first half of September at the relevant atrocity areas in Africa and Europe. And then from that trip onwards, obviously the work then progressed in the office.
Great. So can you tell us a little bit about the critical issues and challenges that really engaged you in the early years in this position?
Right.
And how did the U.S. decision not to join the International Criminal Court affect your work?
By the way, I just want to add one other point about the creation of the office, which is how did we become SWCI, S/WCI? Well, first of all, just naming the office was a huge challenge because what do you name this? And of course, we knew it wasn't just war crimes, it was also crimes against humanity, genocide, and yet everyone associates, war crimes, so it was an easy way to get the issue in front of everyone. So we finally settled on war crimes, but then how do you get S/WCI? And I have to tell you, I turned to my sister, Paula Later, who was in the top administrative executive / executive part of the State Department her entire career. And I said, Paula, how do you go about creating a symbol, for an office? And she said, well, tell me what the issues are. I said, well, it's war crimes, et cetera. And she said, after about 5 minutes, okay, so this is how we do it, Dave. It's S/WCI. So it's my sister Paula Later who created the symbol, okay? So anyway, I would say the major problems that came in the development of the office in the early years, or the major challenges, were first and foremost to sensitize the rest of the federal bureaucracy, the relevant federal bureaucracy, to the issues and the priority of them in the second term of the Clinton administration. And that meant developing further relationships at the Pentagon and the Intelligence Committee and the Justice Department, in the NSC, and the new team at the NSC for the second term, because I knew the first term team. And the second term team, of course, was Sandy Berger at the head of the NSC, who I knew extremely well from the deputies meetings. But it was also just making sure that everyone else in the NSC was on deck with me. And of course, Congress. So those were long days of building an institutional understanding and appreciation of the office and its duties, because I would need to turn to all of these parties for years to get things done, particularly when I have no budget, because I had to raid other agencies' budgets constantly. That meant going in and begging. And so I became a beggar, and that was a huge part of the job, was to enable the United States government to fully support these courts, and that meant with voluntary contributions as well as assessed contributions, and also dealing with the numerous requests. Every day I would get calls from The Hague or Arusha seeking support, literally seeking the support of the United States government. So my job, sometimes in my notebook you would see today, you could turn to a page and there would be 25 action items that would erupt in one day, just 25. Why? Because I was getting phone calls constantly for U.S. support. So that was a huge part of the job, and of course every one of those had a little problem here or there that was your main issue. But I'll just close by saying, in this first round, Jane, I suppose one of my biggest difficulties was related to the International Criminal Court and making sure that all of the efforts that we were putting into the negotiations that culminated in Rome in July of 1998 would be ultimately productive and successful in the creation of this court. It must be emphasized, because this is something we worked on very hard inside the government, that President Clinton was determined that this court would be established. That was his intention. And in fact, it's interesting, after his years in service, if you look at his public statements, they're extremely supportive of the International Criminal Court. So he personally wanted this court established. The issue was what kind of court, with what sort of authority, and how would it be structured? And that's where some difficulties erupted, obviously, in the negotiations. But because I had the determination of President Clinton behind me, I was able to push the envelope constantly within the U.S. government, and I did so fairly boldly because, if someone wanted me fired, all I had to do was essentially go to the White House and say, this guy wants me fired. What do you think about that? And I knew I had the support. I knew I had my back covered by Sandy Berger at the NSC and by President Clinton and by Madeleine Albright. So when you have your back covered, you can push very, very hard and risk yourself and actually make some enemies within the government. But that is just the way it worked. And frankly, I'll just close with this. After Rome, when of course we had sort of the debacle of not being able to support the final draft of the Rome Statute, it took 2 years, 1999 and 2000, of an internal struggle, an internal battle constantly to bring the United States back into the talks, back into the role of having a proactive and positive attitude about the ICC, to the moment where we could finally sign it on December 31st, 2000. That was a long battle, and those were probably my hardest days in government, were those 2 years.
Great, thank you. Thank you so much, Ambassador Sheffer. Now let's turn to Ambassador Clint Williamson. Clint, you served for 7 years at the International Criminal Tribunal for the former Yugoslavia, and you also served as a senior director at the National Security Council during the first term of the George W. Bush administration, and you brought all this experience with you to your role as ambassador at large for war crimes issues, a position that you held during the second Bush administration, and then on into, I think, about 9 months or so in the Obama administration. So you're the one ambassador at large who stayed in office through a transition of administrations. And as a result, it would be very interesting if you could comment on how previous transition processes have dealt with SWCI, as it was called, and how you think the current transition is going, and how you think GCJ might potentially be impacted. Easy questions.
Yes, yeah. Okay. Well, thanks, Jane, and thanks also for the opportunity to participate today and see a lot of old friends. I served in government for a long time. I was a career civil servant, so I came initially to Washington as a trial attorney in the Justice Department during the George H.W. Bush administration, which seems like a very long time ago now. And so I was here through the transition to President Clinton, from President Clinton to George W. Bush, George W. Bush to Obama. And I retired from government in 2014, but I've still had quite a bit of visibility on the current transition and have been talking closely with people that are involved in this, largely from the agency side, not so much from the transition side. I think I can safely say this is the most tumultuous transition I've seen in my time in Washington. But to be fair, I think some things have been overblown. There was a lot made of the fact of kind of mass resignations at senior levels in the State Department. The fact is that happens with every change of administration. In the change from President Bush to President Obama, of the 35 or 40 people who attend the senior staff meeting every day, who are assistant secretary level and above, the day after the inauguration, I was one of only about 10 people still left in that group. So all political appointees are out on January 20th. Even a lot of career people are, if they're in positions that they intend to quickly fill with with politicals. What has been different about this administration is that, first of all, the timing of a lot of this, and I think it was done in a very sloppy fashion. People were not informed that they were going to be asked to leave. People were notified when they got off an airplane en route to some meeting. So it was not handled well in that regard. Secondly, they just have not moved forward with putting people in place to replace these individuals. When you have political appointees or presidential appointees leaving, they always have a principal deputy who can step in and fill the role. And so this government continues to function. And certainly this has been put in place in past transitions to keep government functioning. What we've had here, though, is in the State Department, you only have one presidential appointee in place of a Senate-confirmed position, and that's Secretary Tillerson. There's not a single other person below him. And it's unclear how many people are even in the pipeline to fill those posts. So what has been created is just this huge vacuum there. You do have the deputies running these offices, but they have no political guide or no policy guidance from above on what is expected of them. You have a White House that has been ruthless in dealing with any kind of statements that they feel like departs from their policy. And so it's very difficult for people in these offices to take any kind of action, particularly any sort of bold action. And this is coupled also with these draconian budget cuts, which appear to be coming. And one of the few items of guidance that has come down from the Secretary's office thus far in the State Department is to be very restrictive on spending. So with the War Crimes Office, for example, as ambassador at large, you have to spend a lot of your time traveling. I spent 2 weeks out of every month on the road. Not nearly as much as Stephen, but I traveled a lot. And people in the office travel a lot. And you have to. It is an ambassador at large. And most of your work is done outside Washington. And so by curtailing travel, by not giving policy guidance, it's very difficult for the office and for the department writ large to engage on issues that are important to this country. In terms of past transitions, I think the fate of this office has always come up. When the Obama transition team came in 2008, the first question they asked me was, why should we retain this office? And why does it need to report directly to the Secretary of State? And I made what I thought was a compelling argument for keeping the office. And I mean, I think those same types of questions have been asked during this transition, but these issues have always been resolved by Inauguration Day. Right now, all of this is still up in the air. Nobody knows where this is going. And it's unclear what the administration's intentions are toward the office, but I think the types of statements that have come out generally about the role of functional offices have not been encouraging. And so it has created this very difficult climate for the office. And at this point, I think we can just only be hopeful that the office is retained. It may well be subsumed into some other bureau like International Narcotics and Law Enforcement or Democracy, Human Rights, and Labor, which I think would be a huge mistake. But because of not even having anybody in place at intermediate levels in the department, it's very difficult to gauge where they're going with these issues.
Thank you for your very candid reflections on all this. So, Clint, you served as ambassador in the second term of the Bush administration during a period when the U.S. took a more supportive approach, a moderated approach toward international justice and especially the ICC than had been the case during the first term of the Bush administration. And it would be helpful if you could talk about some of the reasons why the Bush administration in its second term decided to adjust its approach, and whether you think there are any lessons to learn from that that might be relevant for the Trump administration.
I think there are a lot of lessons that they should take from the Bush administration's experience. I was, during most of the first term of the Bush administration, I was at the NSC. I was detailed from the Department of Justice, and I wasn't working directly on war crimes issues there. I was primarily dealing with peacekeeping and post-conflict stabilization and reconstruction. But because of my experience, I got pulled into some of these debates. And I know very early on, I came in January of 2003 there, and even at that point, Condi Rice, who was then National Security Advisor, had developed great concerns about this scorched earth policy toward the ICC that had been led primarily by John Bolton. And she saw that a lot of the things that were taking place as part of this were actually self-defeating for the U.S., and particularly the Article 98 agreements, which she just thought were ridiculous and were causing countries that had been friends and allies of the United States to seek strategic relationships with others. So I think she and some others had concerns with these policies very early on. When she became Secretary of State and she asked me to take the War Crimes Ambassador post, the first thing she said to me is, I want you to focus on undoing the damage that was done by Bolton and others during the first term. And so we looked at this from the very beginning of my time in the job, which was mid-2006 onward, how we could do more in relation to the ICC. We still had in place the American Service Members Protection Act, ASPA, or the Hague Invasion Act, as it's often known. So there were constraints, and there were still policy hawks that were opposed to the ICC in the administration at that point, not, including Vice President Cheney, Secretary Rumsfeld. So we went about this in quite a discreet way, but at the very beginning, we started looking at how we could do things like increased intelligence support for the ICC. I started meeting with Luis Moreno Ocampo on a fairly regular basis, talking about cooperation, and the policy evolved. We started doing a lot more interaction, achieving what Javier Solana had proposed, which was just a modus vivendi between the United States government and the ICC. And by the end of the administration, things had moved where we were much more supportive in the UN Security Council. There was even at one point where there was a vote on the extension of the UN mission in Sudan. And the African Union had pushed this idea of suspending the case against Omar al-Bashir for 1 year with a possible renewal of this for an indefinite period. And the British and the French were prepared to support this. And I went in and had a conversation with Rice, and she said, I think this is a horrible idea. And she basically told me to get on an airplane and go to London and Paris and say we would veto this resolution. And the British and French were just amazed, but quickly changed their position and came along behind it. So you had a huge shift in sort of the policy approach and in the day-to-day relationship over a period of time. But I think also it's important to keep in mind that even in the sort of darkest days with Bolton and the ICC, is the Bush administration remained very supportive on other areas of international justice. With ICTY, ICTR pushed very hard on arrests of fugitives from those courts, expanded the Rewards for Justice program, pushed forward the creation of SCSL, the Cambodia court. So there was a lot going on. So this was not a full-scale opposition to the concept of international justice as a whole. What worries me with this administration is that I'm not sure that anyone even supports the notion of international justice. I mean, maybe with the exception of Nikki Haley, who's made some encouraging statements. But, there's very little that has come out that seems to understand the importance of this issue. And even if you want to look at it sort of in the most realpolitik terms, there are national security interests for the United States at stake here. And I think this is something that the Bush administration came to realize, and it cause changes in policy to be made over time. So I hope they'll go back, they'll look at the record during the Bush administration, they will learn from that, and they won't come in with this idea of just pulling the plug on United States engagement in these issues.
Great. Thank you so much, Clint. Well, now we'll turn to Ambassador Stephen Rapp. You were the longest-serving ambassador at large, serving for nearly 6 years, and traveling to 87 countries, I believe, including 15 trips to the Democratic Republic of the Congo alone, clocking 1,240 total days of travel, an average of 200 days per year, for a total of 1,550,000 miles, equal to traveling around the world every 5 weeks. So there's a reason why you were known as Ambassador at Large. And you served during the Obama administration's creation of the Atrocity Prevention Board. You worked tirelessly in support of hybrid and domestic justice mechanisms in countries around the world. And you oversaw an increased engagement between the United States and the ICC. You also, and I know from my personal experience, devoted countless hours to seeking justice for the egregious atrocities in Syria, including evidence gathering and documentation of torture in Assad regime prisons and of the horrific atrocities committed by ISIS. But in the absence of ICC jurisdiction over Syria, you've looked to other mechanisms, other venues to pursue accountability. And it would be interesting if you could talk a bit about these efforts and what they suggest about the future of global criminal justice.
Okay. Well, thank you very much, Jane, for that introduction, and thank you to the Georgetown Law Center for hosting this great conference. I just want you to know I haven't changed. I was doing my taxes this week, and last year I traveled or worked abroad 298 days. So
even more.
Continuing the outside work that's so important, I think. Just to talk about Syria, I mean, it's just the crimes there are so horrific, so unimaginable. And I mean, we have crimes that, I mean, the code that we've been involved in the United States in leadership from the time of the Lieber Code and during Civil War, and our leadership with the Geneva Conventions and with Nuremberg, et cetera, that those norms are really being destroyed in the Syrian conflict. I mean, we have crimes like the use of poison gas and the direct attack of hospitals, medical facilities, humanitarian workers, crimes that frankly weren't even committed in World War II. And everything that we're working for in the world, I think, really hinges upon whether we can send a clear signal that this isn't the way to conduct a conflict, even to suppress an insurgency. And it is so difficult because unlike crimes in Africa, I mean, 3,000 die in the Côte d'Ivoire during post-election violence. We have an ICC case. We have how effective it is. We don't know. A special cell with international support at the national level. And here we've got a situation where 150 times that many people have been killed with no end in sight. And of course, we know not a state party, the ICC, Security Council blocked by Russian veto. It's impossible to get anything through, not even the most modest sanctions that we've put into effect in the case of other conflicts. They've all been vetoed, and of course, famously, the Russians and Chinese vetoed the resolution, which the U.S. supported and helped gather 13 votes in support of in the Security Council in May of 2014 to send the case to the ICC, and their position remains the same. And of course, the other ideas that we've had of hybrid or mixed courts, they've always relied on the state itself to be working in partnership with the international community. And a regime responsible for 80 to 90% of the crimes is not going to sponsor an effort to hold itself to account. So what do we do? And that's what we were confronting from 2011 forward at the time that I was in the office, and we still confront globally and in the current U.S. government. I mean, we did, of course, support a commission of inquiry and continued to renew it. And one of the things one of the aspects of the job that changed, I mean, is, and to some extent, a reflection of our going on the Human Rights Council and having very able ambassadors and delegates in Geneva to fight for these things. And I hope we stay there after being elected again last year. But using the Human Rights Council mechanisms, even though it's technically a different body of law, but we've now had in the last 8 years, 7 or 8 commissions created, including about 5 of them in situations where the Security Council would have been blocked. So that was an approach that we took early on, and they've continued to file good reports. But they do it entirely on the basis of their own interviews of generally refugees, 6,000 or so. They don't work with other groups. They don't gather documents, of which hundreds of thousands became available in Syria because the government was document mad in terms of the way in which it conducted its operations, nor digital material, videos, or anything like that. That led to an initiative that our office actually initiated in January of 12 and took a while to get traction, but Secretary Clinton actually saw one of the memos that we prepared and wrote on it, let's do it. And that was the creation of the Syrian Justice and Accountability Center, which she then proposed when I was with her in Istanbul on April 1st of 2012. But the idea of developing documentation center that would be supported by donations of states that would really work then with the Syrian civil society and victims groups to gather these records in a professional way. And that SJAC, as we called it, was to be a hub. One of the groups that it supported was another group that's come to be called CIJA, the Commission for International Justice and Accountability, that now has 750,000 pages of documents out of the Syrian conflict, 450,000 videos, an index of 1 million names of people involved in the conflict and victimized by it. So this has given us, I think, a real leg up in terms of laying the foundation for accountability. And coming from Iowa, I always have the attitude, if you build it, they'll come. If it's there, the courts, the judges will eventually turn up. Well, it doesn't happen automatically, though. There was someone that's been involved in this. The evidence is impressive. Another thing that's happened to build it even stronger in a way that will verify it and really ensure that the material that's coming from different groups is corroborated and well supported and consistent with the criminal justice processes is this mechanism that was established at the end of December by the General Assembly, of course, after my tenure, but those of us, I see David Crane here, was involved actively in lobbying for it, and others in the United States and Britain and other countries, 105 in the General Assembly voted for it, only 15 against it. But this establishes a mechanism, independent, impartial, a mechanism to gather the information from the CIJAs and the civil society and the Commission of Inquiry and really build dossiers. So again, of course, it's the challenge of where do you go. Before I discuss that specifically, just to mention an example of the evidence that has come in this process, of course, are the famous Caesar photos, the photos of 50,000 or more people that were murdered in custody of the Syrian government within the detention facilities in Damascus just in the period between December of 2011 and August of 2013 that was brought out by a Syrian police photographer. And the most impressive evidence that I've ever seen, David Crane was involved in the first analysis of it in January of 2014, but I took it up, became very close to Caesar, helped bring him twice to the United States in July of 2014 and again last month, and worked to protect him, and then to develop the analysis on exactly who those people are, how it was happening, who's in charge of those facilities. And that, of course, is immensely powerful evidence because it's evidence made by the regime itself of people that it has murdered in identified institutions with identifying markings on the bodies. I mean, the Nazis didn't even produce that kind of evidence for Jackson and others at Nuremberg in terms of identifying those victims that you sometimes see in photos. And so it really is incredible stuff. And but of course the frustration is you've got the best evidence in the world, but no court to take it to. There are ways to do it, and some progress is finally being achieved. It does involve extraterritorial prosecutions, and I was involved with a group that in early February filed the first case in Spain based upon a sister of one of the victims who we'd identified in this process, a person murdered in Unit 248 of the facilities, pictured in Caesar's pictures from July of 2013, identified by his sister, who he was very close to, who was a citizen, had been a citizen of Spain for the last quarter century. Spain has restricted its laws on universal jurisdiction, but this isn't universal jurisdiction. She is a victim of this crime of enforced disappearances, recognized as such under Spanish law. And so she has the right to access Spanish courts, and we petitioned for a criminal action based upon and named 9 high-level individuals, including those in the facility and those up to just under Assad. And we were very pleased that last Monday the Spanish judge found that it was that the case was legitimate under Spanish law, admitted it, and ordered the beginning of evidence taking of evidence on April 9th. They're also in Germany, similar case actually on more pure universal jurisdiction. Germany is a country that never really got in any political hot water for their universal jurisdiction because the prosecutor has to certify basically the case is in German interest, and has declined to do that in some of the politically motivated petitions that have come in. But 6 victims of the 6 surviving victims of Syrian detention and several surviving relatives of those killed in Syrian detention petitioned on March 1st to open a case in Germany. In fact, the German prosecutors had an investigation going on the Caesar photos for a year, also another one on Yazidi cases, which we've actually seen arrest warrants on, and the German prosecutor publicly welcomed the case. And so, first time that's happened. And so I think we're going to see a prosecution in Germany. France has been investigating for 2 years, and I think they finally have a way to get into jurisdiction. So this is it's not as good as having it in Syria, it's not as good as having it at the international level, but we clearly trying to use what we have here to clearly send a message that the day of justice has arrived, and I think from this point onward, this will these cases will come forward, and I think in the context of the peace negotiations, which have been largely impossible because the people who represent the 11 million Syrians, it's even more than 11 million now that have been displaced, can't really make peace with the government without any assurance that there's not justice. So you've got that blockage. Of course, we know how difficult it is to negotiate peace in this context, but this, I think, clearly sends the signal that justice will not be dealt away in any peace agreement, and it can't be if we're going to have genuine peace.
Thank you so much, and for all that you're doing on this tirelessly. I also know from personal experience that much of your work as ambassador focused on building domestic capacity, including through mixed courts in places like the Democratic Republic of the Congo, the Central African Republic. And I would be interested to know what, based on your experience, you think the key ingredients are needed to make such initiatives more successful. You know, what's the sort of heart of the things that you need to make these mixed tribunals in these challenging situations more successful?
There's no question that international courts can't do it all, but I do think that the key thing is to work with a dynamic where international efforts are important to bring the matter to attention, to go after sometimes the senior individuals, and then that you then look to the national system to carry that forward. With cases against mid or lower level people or against high level people that weren't prosecuted by the international one. And the great model, of course, is Nuremberg, where eventually there were, not a direct process, but all the evidence was then shared by the U.S. With the German prosecutors in the 60s that began their own prosecutions, and even today are prosecuting camp guards in their 90s, et cetera. And that, I think, has made Germany sort of a model of a country that's put its past, that's dealt with its its past and has changed its whole approach to the world, and where certainly the crimes committed by the grandfathers, are not approved of by Germany today, and so that's so important, I think, in the process. We've had some of that in the former Yugoslavia because of the transfer of cases and the dynamic of those countries coming in or trying to come into the EU. But of course, as we learned in the Balkans, even in a country like Bosnia, which is so divided, that having a court there and having a trust with the victims and affected communities, doing it alone in the national level, even with the communities, each of the communities represented in the court, was a very difficult thing. And so there, the idea of adding internationals as prosecutors, as judges, even on a temporary basis, initially as a majority, eventually phased out after 5 years plus then a 3-year extension, I think gives us something that's much stronger than we would have had otherwise. And that's where most of the situations where we've been dealing with the idea of mixed courts, and by mixed, I mean the nomenclature of these, we talk about hybrid courts. I tend to view hybrid as the more treaty-based courts, the courts in which there's a treaty between the country and the UN, or the country like Sierra Leone or Cambodia, or the country in the AU, like even the Habre case. But a mixed court is a court established under national law, but a court that then has a relationship with the international community, where internationals may be able to nominate judges and prosecutors, where internationals may be donating resources and building capacity, as was the case in Bosnia. But in other places, like the DRC, where the ICC is prosecuted now, I think 5 people, we know that in terms of the crimes that have been committed there and in the 90s, which are outside the ICC jurisdiction, and even more recently, can't be done by the ICC alone. We've had some progress at the national level with mixed courts. Hello, Chief Justice. Good to see you here.
Yes.
Yes.
Welcome, Chief Justice Jallow.
But it really, the idea of we've had mobile courts and efforts, but they've generally been going after very low-level people. One of the reasons why my all-time favorite proposal, I see Anna Cave here, who was so involved with me in this, one of the reasons I went to the DRC for 15 times was trying to get a mixed court in the DRC, and everybody's supporting it, but the legislation still hasn't happened. Central African Republic, however, is a place where we did succeed, and we now have a mixed court, and judges are being appointed. A prosecutor, including our good friend Colonel Montezini from the DRC, has been appointed as chief prosecutor. So I think this gives us some hope, even in a place where the ICC is prosecuting 2 or 3 accused. We've got the possibility of building justice where it wouldn't be possible otherwise.
Thank you. Now I'd like to turn to Professor Diane Ornt-Licker, who is a world-class academic expert on transitional justice and international criminal tribunals. She's also served as the UN independent expert on combating impunity and in other important roles. And you brought all this background to your work as Ambassador Rapp's first deputy in the Office of War Crimes Issues. And I know you were deeply involved in the Obama administration's review of U.S. policy toward the ICC. And it would be interesting if you could say a bit about the reasons why the administration decided in favor of greater engagement with the court, and were there particular benefits as well as challenges in that approach?
Sure. Thank you. First, I want to thank you for the invitation. It's a delight and honor to be here. Like everybody else, I have great memories of Samuel Dash, so it's wonderful to be part of anything that honors his legacy. I think about 16 or 17 years ago, I actually spoke to a seminar or practicum here on these very issues, and he was one of the most engaged and energetically brilliant sort of co-teachers on this subject. So anyway, it's wonderful to be here. So I think what happened at the beginning of the Obama administration to lead to the policy you asked me about was a confluence of a number of developments. Clint already touched on one of them, which was that the outgoing administration itself had evolved on the ICC. During the first term, the Bush administration was quite hostile to the ICC, and as Clint indicated, that was driven significantly by the views of a particular individual, John Bolton, who was no longer part of the administration in the second term. But the second term, again, as Clint indicated, there had really been a striking evolution from an early first-term policy of hostility and suspicion to a recognition that the ICC was valuable. And I'm not sure Clint touched on that part of it. So the Bush administration had abstained from a vote on referring the Darfur situation to the International Criminal Court in 2005, which allowed that referral to go forward, first Security Council referral. That would have been unimaginable in the first Bush term. And so there were two things that happened then in the second term of the Bush administration. One, as Clint discussed very helpfully, there was a keen awareness that the earlier policy of hostility had a lot of negative repercussions across the board, not just in our human rights related policies, but across the board. There was a backlash that affected U.S. interests and diplomacy in a lot of different areas. So that evolution kind of took us to the beginning of the Obama administration, and it was a helpful foundation for us for a variety of reasons, one of which was that I think it meant that when we came into office, I'm sorry, not we, but President Obama, the issue of the ICC was, I think, not so much seen as a partisan issue as it might have been. So it wasn't just, okay, so the Republican administration hated it, the Democrats might have a different view. Rather, the Republican administration had evolved, and we, in many significant ways, picked up where they left off. And I think that was super helpful in the transition moment to be seen as continuing an evolution under the previous Republican administration. Second key factor was that the leadership in the Obama administration was disposed to support accountability for all the reasons I think all of us are involved in this work. There was a sort of genuine, deep understanding that when you see the kinds of horrific crimes that Ambassador Rapp just talked about, victims need justice. We don't want to live in a world where you can kill, torture hundreds of thousands of people systematically, and the world says, yeah, whatever, let's move on. And so the leadership got that, and I think what was also super important and helpful, this really gets to your whole theme of this panel, I think, of what it means to have experts embedded in the government. There were senior officials like Ambassador Rapp, who is a force of nature on these issues, Samantha Power, a host of Harold Koh at the State Department who were very deeply committed to these issues, and then deputies in key offices who were deeply, passionately committed to these issues and had expertise. And so there was a real critical mass of dynamism. And one of the things that I think is so important in making progress in this area is being relentless and having expertise. And again, I'm sort of fortunate for who has come before me in this panel, because I was thinking as Ambassador Rapp was talking, how much just listening to him talk is a seminar in how you make change in the world, because sometimes it takes a really long time of investment and passion to bring about the kind of accountability that ultimately I think is necessary for many situations. And so there were people in the Obama administration who were committed and who had sort of the long view of these issues, and if there wasn't going to be an opportunity to advance justice right away, they knew how to set the foundation for that process to happen and to stay on it. And the third thing that was really important was an interagency process. I'm going to get bureaucratic here for a moment. So what I've said so far, and what Clint also talked about, makes clear that there had already been an evolution within the State Department and the White House on the question of a relationship to the International Criminal Court in particular. Not every agency in the U.S. government was involved, though, in that evolution. And when we started doing our work at SWCI, as it was then still called, there had not been a comprehensive look across the U.S. government at the International Criminal Court, maybe since David went to Rome. I mean, it hadn't happened. And so there were agencies, particularly the Department of Defense, that had not actively participated in the evolution that happened in the second term of the Bush administration. And it was important that we not just sort of move ahead without them. And so the review process that happened during the first year of the Obama administration, I mean, it sort of never stopped, but the key course change happened in the first year, involved addressing DOD's interests and stake in the International Criminal Court. And what emerged from that process is something that some scholars have called, I think I'm getting this term right, overlapping consensus. You had a consensus among key agencies to move forward in engaging in an affirmative, systematic way with the International Criminal Court. But the consensus reflected maybe somewhat different motivations for different agencies. And for the Department of Defense, I think one lesson they had learned from the perspective of their interests was that it wasn't helpful to their interests as they understood them for the United States to have been absent from the International Criminal Court, that it, from their perspective, was more productive to be at the table, to have an opportunity to say, okay, so we get why you want justice. We understand that, but here are our concerns, and we hope we can find a way to model justice in a way that addresses our concerns, as well as the very important values of justice that you're addressing. So again, their perspective was it's in our interest to participate, and that perspective I don't think was there when we started. That developed, that emerged as a result of the interagency process we developed. Those of us who were involved in these issues in the State Department and White House were passionate about these issues. And so the kind of engagement that emerged was able to happen because DOD's concerns were addressed. But it wouldn't have happened just because DOD I think, came to see that it was in its interest to participate in ASP meetings. What made the energy for the policy, the dynamism, came from people like Ambassador Rapp and the cohort that I alluded to earlier, which was like an amazing team, honestly. One of the best things about being in government at that time was the phenomenal cohort who were actively, passionately engaged in these issues across agencies during the period that I was there. And Jane, you can probably speak to your period. So again, a number of different factors came together to produce the policy that we developed.
Great, thank you. Thank you so much. I know Ambassador Williamson would like to comment briefly.
Just very briefly, I just want to reinforce the point that Diane made, and I think that's correct, is what we were doing in the Bush administration was largely a very quiet initiative by the State Department and with the NSC on board with it, but without the full interagency engaged. And in fact, the first interagency meeting that took place during the Obama administration on this issue, which was chaired by Samantha Power, and she kicked off the meeting by asking what we had been doing in terms of the relationship with the ICC. And I started going through intelligence support and meetings that I was having with Luis Moreno Ocampo, and there was outrage from others in the room, and these were career officials, largely from the Defense Department, but also from the Justice Department. And people were saying, you can't do that. You weren't allowed to do that under ASPA. No. So, I mean, I think Diane makes a very good point that Where you saw this huge evolution was in bringing the interagency on board with this. But it goes back to the point that this requires political leadership to do this. And that's what we're going to have going forward.
Great, thank you. Diane, I know that you were also very involved in a lot of the innovative forms of accountability, mixed courts and so forth during your tenure at SWCI. And I'm wondering if you can discuss any lessons learned from these initiatives, including ways that the U.S. sought to better ensure, when possible, that the efforts were part of a holistic effort to address needs of victims.
Right, sure. So just to begin, I want to make one point that links your second question to the first one. Part of what the United States had to do once we made a decision to engage with the ICC, which meant the first sort of tangible thing that meant was that we started going to meetings of the Assembly of States Parties, the ASP. And so we had been absent from every previous ASP meeting. Suddenly we show up, and we were a bit of a spectacle. I mean, the United States showing up at the first ASP meeting, you don't go unnoticed. We're not, diminutive.
Especially when it's a large delegation, larger than many states.
We were ginormous. And so there were
People watching us.
Yeah, people were watching us. And so the message we made at that first ASP meeting, I think, was super important and symbolic. So a lot of people, understandably, were skeptical of why we were there. And there is a narrative in the literature that said the United States came because the crime of aggression was going to be discussed and they wanted to protect their interests. And that misses a lot. I mean, that may be why DOD became comfortable with the idea of participation, or that may be a big part of it. But it's not why we were there. And so the message that Ambassador Rapp delivered was, first of all, my recollection is that there was, despite our big footprint, was a message, a fairly humble message. We're here to listen. But the center of the message was, we haven't been at these meetings before, but we haven't been absent in the cause, and we have never lost our commitment to these issues. And the long legacy that begins at least with Nuremberg has continued across decades. And there was nobody more credible delivering that message than Ambassador Rapp, given his history at the Rwanda Tribunal and the Special Court for Sierra Leone. And so reminding our colleagues from other countries that we had stood shoulder to shoulder with them, I think that those words were in your remarks, was, I think, an important part of sort of signaling we're really here to work with you toward the same goal. And yes, there are some concerns within our government. They're real. We're going to address those concerns, but please know that when we say we care about justice, we mean it. That's not just a cover for addressing sort of realpolitik concerns. In terms of some of the lessons learned, let me start by saying I think in part because of the legacy that David and Clint left us, other departments, the regional offices and other functional offices, had already learned some lessons, which involved the value of having concentrated expertise in the Office of SWCI. And so it's hugely important that there's a person you can call like David Sheffer when a crisis arrives. So, if I'm surprised by his list of 25, it's only that it's not longer per day because emergencies develop. I remember I called David once when, it must have been the late 90s, when a Cambodia expert I know who was in Cambodia called me probably in the middle of the night and said, Pol Pot's available. He's been, his associates have turned on him. They want to turn him over for trial. Where can they send him? And I called David, and I think David was shoveling the snow in his everything. So, and so David talks about this episode in his book. So it's important to have an expert that you can call. at those moments, and that's one of the reasons SWCI is, and GCJ now, is so valuable. But also, regional offices get those calls, and often. And so frequently, an assistant secretary of state for a particular region would get a call from a newly elected leader in a volatile region saying, okay, we've just had this tumultuous change of government. We have a window now. We want to get started right away figuring out how to handle this. We know these windows of opportunity are crucial. What do we do? What are our options? And those offices knew to call SWCI. And it happened fairly often. And it was, so one of the lessons the bureaucracy had learned is, even if it's not your portfolio, you need to address these issues, and you want to have experts you can get mobilized right away to help you on that. And we would get calls, sometimes from somebody in the White House who was about to get on the next plane to go to a region where something turbulent had happened, and the new government wanted guidance, and they would say, send me an option paper, my flight is leaving in 2 hours. And if our office didn't have really serious expertise, I think we would have failed our government at crucial times. There was one moment, I'm going to be discreet about the country, but we had to make a highest level decision about whether to support a particular mechanism for a particular country in transition. And Ambassador Rapp was away. The deputy secretary called a meeting on very short notice. I think there were about 20 of us representing different offices, and I think it was just within the State Department to decide what to do. And it was like a do or die meeting. And the deputy secretary ended up being almost a dialogue between me and him, because other people in the room didn't know the answers to a lot of the questions, which were about what are the history in other countries with this? What about this example? What about that example? Didn't something like this go wrong somewhere else? And I was able to answer those questions to his satisfaction, I hope. And so the expertise is critical. I'll say, I think Stephen has addressed the innovative models I won't say more about that. Let me say a couple of more general points. One of the things that I think we knew because of the expertise concentrated in our office is that you can't just say, here's a tribunal and it will solve all your problems. That tribunals have an impact in a context, and that if you don't address other things going on around the tribunal, your investment may not turn out the way you hope it will and won't have the impact it should have. And so we work very closely with other offices, like the Office of Global Women's Issues in the Democratic Republic of Congo, to ensure that our justice-focused initiatives were surrounded by other initiatives dealing with things like social economic needs of survivors of mass rape in the community, and that it wasn't that we weren't placing an undue burden on criminal justice. So that expertise was important. I think what also was helpful is that not only were we nimble enough to respond to windows of opportunity as they developed unexpectedly, but we also, and I already alluded to this, had a long view, and know that the work of justice after a country has been convulsed in ways that are often hard to imagine, that work is a long-term project. And unfortunately, it's super easy and natural for the governments that launch initiatives to sort of move on to other issues after a couple of years of aggressively supporting those initiatives. But the initiatives reach stumbling blocks, to put it mildly, and need relentless support over time. And so one of the things that I think has been great about having this dedicated expert office is that it marshals the support you need to marshal across government when initiatives run into trouble and need help getting over the next stumbling block.
Great, thank you so much. I want to make sure I leave time for audience questions, but I do have a couple more I want to just posed to the panel in general. And one was on the importance of having a dedicated office like this continue on into the future. It's been in existence now for almost 20 years. Its fate going forward is uncertain. And I think all the panelists in their remarks have given a number of reasons why having such an office is so important. The leadership it can provide, if there's an ambassadorial level person especially leading it, the expertise it can provide, the energy. It's a focal point for engagement by tribunal officials. They know the go-to office, the go-to person that they need to talk with if they need help. It's an engagement point for other countries, for other government offices, for Congress, for members of Congress. I mean, these are some of the themes that have come up, and I want to give the panelists a chance, if they wish to, say anything more about why it's important to have this office going forward. And maybe, David, since you were present at the creation, you might have some thoughts.
I think it's a very important question. I was extremely proud, as the first ambassador at large for war crimes issues, to travel the world and meet with other governments, and with great pride state the commitment of the U.S. government to the rule of law, to international criminal justice, even in the face of our difficulties at Rome, to still keep at it, because we had enough credibility, we still had enough promise in what even our relationship with the ICC could be, to make the point as the most powerful nation in the world that this is part of why we are the most powerful nation in the world, is because of what I'm just about to say to you, which concerns international criminal justice and our support for it. To me, that was the most, significant characteristic of my job. And it gave me tremendous influence and authority, and I could change things. I could influence matters overseas with other governments. I could pressure them because I had the American reputation for that issue supporting me. Despite all the criticism our country gets at times overseas, it was still absolutely essential to have credibility to walk into the room and make that point. And I think that's what all of my colleagues have done at this table. And my great concern, of course, is that at some point you will lose that credibility if you don't nurture it and support it and back it from the highest levels of the government. And that's a concern that I have today, that I hope that this office can be sustained throughout the current administration, but that secondly, there are leaders who give the ambassador at large, and let's hope there will be another ambassador at large, that sort of support and also actions every day by the U.S. government that enhance that credibility. The only way you can make that point as an ambassador is if the rest of the government is in fact pressing similar issues with similar credibility on all fronts, because then you can state as the most powerful nation, I am here to represent international criminal justice, and there is an expectation that you will listen to me and be somewhat impacted by what I'm going to say to you. That's the job of the ambassador, is to go overseas and make that point to other governments. And I did it with tremendous pride, and I just want the current or the next ambassador to be able to do the same.
Thank you. Any?
Yeah, I would just add to that, I totally agree with everything that David has said. But I think there's another aspect to it as well that's very important, is we all know what has become sort of a cliche, but the peace versus justice debate. And this goes on around the world, but it also goes on inside the State Department on a daily basis. And all of us have been engaged in these epic battles with our counterparts who were assistant secretaries of regional bureaus, who oftentimes are arguing for doing what is the expeditious thing at the moment, expedient thing at the moment, to, it's been so long, let's move on. We don't really have to harp on these war criminals anymore. We have a strategic relationship at stake here. Let's just move forward. And so having somebody at the ambassadorial level, and this was the argument I made during the Obama transition, having somebody at the ambassadorial level who is reporting directly to the secretary empowers you to engage in those battles. And if this office ends up being subsumed under INL or DRL, you're going to lose another voice who is advocating for these causes at that level. And it's hard enough doing it when you're fighting against regional bureaus, but the fewer voices you have engaging in that debate, the more often these issues are going to lose.
Thank you so much. Yeah, Stephen, did you want to add?
And just to reinforce that, because, I mean, periodically, people or anyone coming into a new administration looks at the State Department organization chart, and they see a lot of special envoys. I mean, there are only 3 or 4 ambassadors at large, but there are at least 15 or 20 functional special envoys, and they say, can't we rationalize that? Can't we park all these into particular offices? And that's a natural instinct and sort of to clean up the chart, and that's something we always have to sort of fight against, at least in this area, because if you don't have somebody pushing for it, any of the places where they wanted to talk about parking us, even in the legal advisor's office, if we were there, the legal advisor has a broader issue of U.S. Interests in terms of international legal commitments, and could say, no, we don't want you traveling there, or that'll create a bad precedent, or wait a while on that one. If we were in DRL, there's a greater focus on sort of a broader human rights development, and sometimes criminal prosecution's inconsistent with that. I mean, it's very hard for us to push for these issues if we don't have that level of independence. Under the Secretary Clinton's QDDR, or Quadrennial Development and Diplomacy Review, we did finally go into the J Bureau, which is a little bit more of a coalition of groups, and I think that's worked okay for us. But if you do eliminate this office, you will lose the ability of it to take initiative. The other point, of course, is in dealing with the regional bureaus and being essentially at the level of an assistant secretary and being able to enter that space. Now, as Clint told me when he was briefing me on it, he said, if ever you take on the regional bureaus head on, you're going to lose. It's true. But we were able to develop relationships on, particularly in the Africa Bureau with Johnny Carson and Linda Thomas Greenfield, and in South Central Asia, particularly with Bob Blake, where we were, right in there in terms of their own thinking, et cetera. And so your ability to develop those kind of relationships where you become a real partner with that bureau and where you sort of on your issue, you kind of take them over in a way, though of course they see the value of that, is essential if we're going to succeed in a lot of these difficult places, and we wouldn't have that without an independent office.
Thank you so much. I want to just put out one more question to the panel, and then I'll open it up to all of you. And this question has to do with the U.S.-ICC relationship, which obviously has run through different cycles and has been different and evolved over time. But my question is, where do you think the U.S. relationship with the ICC is heading right now, particularly in light of the Afghanistan preliminary examination, which might end up being an investigation? And how do you think the U.S. should navigate the challenges ahead in that relationship?
Any of us?
Yes, I know you'll all be eager to answer that one.
We need to get to Diane, but I just want to state that on the Afghanistan issue, I would hope that there is a dialogue that's taking place between the United States and the United Kingdom at this point, because the United Kingdom has been dealing with an investigation of the United Kingdom at the International Criminal Court with respect to its actions in southern Iraq. I mean, it's a preliminary examination. And I know that there's been an intensive amount of dialogue and interaction between the court and London about that situation. And I could be better educated by others on this, but I have the impression that it remains fairly well managed, that the British commitment to the International Criminal Court, and of course they're a state party, remains quite firm. And so I would hope that there would be some discussions about if certain actions in Afghanistan do come forth for an application by the prosecutor to the pretrial chamber to start an investigation, that there would be some discussions that would help the United States get through that.
And let me just jump in here. I was just in Europe a few days ago, and generally, it does appear that the prosecutor is deferring a bit on this question. In her preliminary examination report in November, she said that she would be filing imminently to open an investigation in Afghanistan. And I understand it's not just us, it's also the Taliban. It's a conflict zone for certainly all the time that the ICC has been in existence. And so it's not just whether the U.S. crimes are grave, it's all of them together that would be the determination. So once she does that, I think it's quite likely that it would be opened. But it looks like it may be deferred to the end of the year as she continues to engage in dialogue with various parties, including the U.S. and Afghanistan. And I think that does give us an opportunity. My own view, frankly, is that particularly in the wake of the Senate report in regard to the intelligence community's detentions and renditions, et cetera, that we really do need a special counsel. That seems highly unlikely given what the President Trump has said about torture. But I do think that there's an opportunity to engage about what we have done in our system to hold people to account and even to provide more information on the Durham investigation, et cetera, that would be useful, and that discussion should continue. The best answer on Afghanistan is complementarity. It's to show that we, even if we didn't prosecute particular individuals, they weren't cases that were cases that one could go forward on, given the necessity of proof in a very complex situation. So we need to make that kind of showing.
Mm-hmm. Great.
And just very quickly on that, the British effort or the British sort of process of dealing with the ICC and doing their own internal investigation has been led by Andrew Cayley, who was the former prosecutor at the Cambodia court. And GCJ has been in touch with him and has been working with him on this. But again, it just goes back to the point we've been making of the importance of having this office. And I think DOD has certainly realized the importance of having people who are knowledgeable about this, knowledgeable about the process, about the substance of these issues, engaging with their British counterparts on this. So again, it just reinforces the point of the importance of GCJ.
Diane, did you want?
What they said.
Yeah, okay, great.
Okay.
Yeah. Okay, go ahead. Yeah.
No, I want Diane.
Oh, Diane, no, did you want to add?
No,
echoing.
I was saying I agree with
Oh.
everything that's been said. I
Great,
think
great.
engaging on this issue in a constructive way is obviously, I hope obviously, the most effective way to respond.
May I throw in just one anecdote, please, from 1999 and 2000? We were confronted with somewhat similar situation with the Yugoslav Tribunal over Kosovo, when we were confronted with the news breaking that Prosecutor Carla Del Ponte, while on vacation in the Alps, had told an Italian reporter, "Oh yes, we're investigating the United States for bombing Serbia." I was pulled out of my vacation, my very short Christmas vacation, back to Washington, and I had to peel Sandy Berger off the ceiling of the National Security Council. He was so enraged over the reality that somehow the Yugoslav Tribunal was investigating us for the brave actions we had taken in Kosovo, and this was a shock to him. It took about 4 to 5 months, but we did it, of working very, very closely with the Pentagon, working with the prosecutor's office, responding to a list of questions by the prosecutor's office about each bombing run that was in question over Serbia. What was the rationale behind it? What was did we meet all of the legal principles of distinction and proportionality and necessity? And, did JAG officers look at each of these? How did that process run, et cetera? And we did it. We responded. It was painful. There were lots of angry people in Washington. I was persona non grata in various offices because they just couldn't believe that we had created a tribunal that was investigating the United States. And yet we got through it. And for better or worse, there was no prosecution of the United States. A lot of academics have criticized that. But the point being that we only succeeded because we engaged. We engaged closely and carefully, and we took it seriously, and we were not intimidated by the process.
Great. Well, at this point, I'd like to open it up. I have many more questions, but I'm sure you in the audience do as well. And I'd like to welcome questions from the audience. I see there's one in the back. Yes, if you could come to a microphone and maybe just identify yourself and your affiliation and pose a succinct question, that would be wonderful. Thank you. Hopefully.
Thank you. Good morning, everyone. Thank you for being here today. It's an absolute honor to hear all of your reflections. My affiliation, I was at Northwestern Law and had the benefit of attending some of Professor Sheffield, Ambassador Sheffer's classes. Brilliant insight on international law and criminal justice. My question, I've had the benefit of reading Ambassador Sheffer's book, All the Missing Souls, and your reflections today reminded me of certain passages, and especially in relation to the stagnation of the decision-making process at times, partially due to the bureaucracy in Washington, D.C. And there's a certain passage where you talk about defining genocide, defining what was going on in 1994 in Rwanda as genocide, and you go back and forth to different agencies, and it's a fantastically detailed account of what was going on. And what actions did you each take in order to improve that decision-making process in the face of allegations of war crimes in conflict zones during your times as working in the as ambassadors at large and as experts? Thank you.
Does anyone want to take that up?
I mean, I'll start maybe with this, but I think all of us have been, and I don't want to speak for the others, but we've all been engaged in trying to develop U.S. capabilities for response. And I think the Atrocity Prevention Board is sort of the culmination of these efforts over many years of getting to the point where you have this body that is dedicated to these issues. But ultimately, it comes down to a question of political will. And I was at the NSC during the Bush administration when Darfur was going on, and I was present for a lot of debates that were taking place there. And President Bush really wanted to do something about Darfur. And so you have, in that case, the President of the United States wanting to do something about these issues. But as I said, you know, as I was participating, or actually as a note taker in these deputies committee meetings or principals committee meetings on these issues at the White House, you have the Defense Department coming in and saying, Mr. President, we're already committed in Iraq and Afghanistan. In order for us to do something militarily, we're going to have to denude our assets, our NATO assets, and it's going to take this and moving all this around, and it's just not feasible to do. And you have the State Department saying, Mr. President, we have already invaded 2 Muslim countries in Iraq and Afghanistan. If we invade a third, the political fallout, the diplomatic fallout is going to be huge. You know, and the list goes on. And these were all valid arguments. These were all things that should have been put on the table. And in the end, President Bush decided he couldn't act in the way that he wanted to. And I think you've had the similar dynamic going on in relation to Syria that's taken place in this administration. So sometimes the perception outside is that you have everybody sitting around the table and it's just this kind of cold-hearted decision by government bureaucrats that we're not going to act. That, you know, despite these people dying, we don't care enough to do something. It's not that straightforward. It's trying to find common ground with all these different equities that are being brought to bear. And that's the difficult thing to overcome. We can put all the capabilities we want in place, we can have the APB, but if you don't have the political will to overcome these issues and to make a decision saying, this is our foremost interest, despite all of those concerns, you're not going to have the kind of action that you need.
Thank you, Stephen.
Yeah, just to follow up, and I think the creation of the Atrocity Prevention Board is essential in this area, because you do have a body meeting at a high level, at least at an assistant secretary level across the government, across the national security system, monthly on these issues. I mean, before that in the administration, we did have a director, and we had the active engagement of Samantha Power, so we were able to engage the interagency as well. But you need that focus, and David could confirm this, but people have said that during the whole Rwanda crisis, there never was a meeting on Rwanda that was scheduled at least the deputies level of the National Security Council. I presume that's the case. And we were able to do it. That did, certainly in situations like the Central African Republic in 2013 or in other crises, and not allow us, one, to speak out very clearly on what we saw, and two, to take some action in terms of reinforcing the peacekeeping force with robust units and other things. The challenge, of course, is sometimes even this question of whether you're going to call something a genocide is challenging. And we do have a process. It was followed back in 2004 when Secretary Colin Powell declared what was happening in Darfur a genocide, and involves teeing up a question which the Legal Advisor's Office, with our assistance, makes a determination. One of the remarkable things, just as I was in my last year, as we dealt with the crimes of ISIS in northern Iraq, and particularly what I frankly thought was a genocide against the Yazidi, and certainly massive crimes against humanity, against Christians and other groups, was getting a determination teed up. And there, of course, we were in a situation where we had actually done some intervention at the very on Sinjar. The president and the secretary had spoken about the hallmarks of genocide, but getting that determination was difficult because we were in a conflict. We didn't, to some extent, these things are easier when you're dealing with a situation like the Central African Republic, where you're not engaged militarily, and the sort of implications of what a declaration means in terms of what we need to do militarily makes it hard to get that. In the end, that determination came from Secretary Clinton, or Secretary Kerry in March of 2016, but that was based upon Congress actually passing a rider on an appropriations bill that required such a determination in 90 days. So that's what took it to go. That does raise the issue of a relationship with Congress, and I think that the one asset that we do have during this administration is we have some strong Republican allies in Congress, and cultivating them and pressing them, whether it's Congressman Royce or Congressman Smith or young Adam Kinzinger, or there are good people on the Senate side as well, I think gives us the chance of preserving the priority on these issues, and maybe even preserving the office.
Yeah, I would just add, a couple of us have made reference to the Atrocities Prevention Board, and I'm not sure everybody's familiar with it, but one of the initiatives of the Obama administration was to try to understand why the bureaucracy had not responded effectively to threats that might culminate in genocide, and to figure out what we can do bureaucratically to lessen the likelihood that that would happen. And I was involved in developing the sort of groundwork for that, but it was launched after I returned to teaching, so I'm not familiar as an insider with how it's operated. But when it's discussed in the press, it's usually to say, so after it was created, Syria still happened. But what I think is not, which is, I would never minimize the shame of that. So I don't want to trivialize that. That is a stain on our conscience, and there is no, I don't want to say anything to minimize that. But what I think is not understood is that one of the concepts of the Atrocities Prevention Board is to ensure that we don't get to the crisis level. And so the monthly meetings that Ambassador Rabb referred to involve briefings, as I understand it, about latest current intelligence briefings that are meant to identify risks at an early stage so that the U.S. government and its allies can marshal an effective response at a point where it's much easier to be effective in heading off a crisis than much later in the process where a situation has already gotten out of control. So there are a bunch of other things that sound really tedious and boring, but hopefully matter a lot, like training foreign service officers, in recognizing early warning signs, maybe in knowing genocide when you see it, but knowing how to alert the bureaucracy very early on so that the steps that are far more feasible to prevent a worsening of a situation can be taken in real time before a situation spins out of control.
Other questions? Yes.
Hi, I'm Laura Dickinson. I'm a professor at George Washington University, and I'm currently serving as special counsel at the Department of Defense. Everything I say is in my personal capacity. So thank you all for your presentations. There is a lot of wisdom and a lot of experience in this room. Let's imagine that the prosecutor does open an investigation in Afghanistan. What would you recommend the legal strategy of the United States should be? I also have a second question on another topic, which is, what do you think the way forward should be for accountability for ISIL atrocities? Not within the framework of terrorism, but within the framework of mass atrocity crimes.
Thank you so much. These are terrific questions, and we'll give some time to the panelists to answer them. We have a coffee break scheduled from between 11 and 11:15, and so there is coffee back there. There will be a chance to mingle informally, but I think these were excellent questions, and we need to give some time to attending to them now. So, any takers?
Well, let me just, the two questions, I mean, and to some extent what I said earlier, we need to engage and show that we have had a genuine process, that we've investigated these things and throughout our government, whether in the Senate or through the Department of Justice or through military justice, et cetera, and push that point forward and show it. And I think we've got a lot to show in that area. The United States does prosecute its own. It prosecuted at Abu Ghraib. It prosecutes the Whitewater or the Blackwater guys that shot people in Nazir Square and they got 30 years to life. I mean, we do things, and we should put that forward. On the question of ISIL crimes, I do think that, and I know the office, I see Matt Krause here, working very closely with Iraqi and authorities of the Kurdish regional government to try to increase their capacity to try the crimes of ISIS, particularly the sexual enslavement and the rape and the mass violence against Yazidis and Christians and others that really does qualify as genocide and crimes against humanity for those crimes, and not simply trying them as trying individuals as material supporters to a terrorist organization, which allows those individuals to look like martyrs to the caliphate or to religion, but actually show them, talk about raping 9-year-old girls or doing the kind of horrendous things that they have done is one of the ways that we reveal ISIS' true nature. That's not an easy thing to do. One of the reasons we prosecute CT cases on material support is very hard to develop the information inside those organizations, and that's why these documentation efforts are so critical, and building that effort. But I am hopeful that we will have a process in Iraq or in the Kurdish region within the next year or two that will be able to pursue those cases, and I think that and ideally, in my view, it would be a mixed court, not necessarily including non-Arabic speakers, but certainly people from the region and from the various communities that could ensure that these were fair trials.
Great. Thank you, David.
Not to detract at all from Stephen's excellent proposal, because I think it's worthy of pursuing, I think there might be another option. Given the current character of the government here in Washington and its well-known relationships with certain governments, including Russia, it seems to me that it would not be beyond the realm of possibility that there could be a political understanding among the United States, Russia, and China in the Security Council, and then bringing France and Britain along to make a referral to the ICC by the Security Council of ISIL over several jurisdictions, particularly those of non-state parties to the ICC, so that you'd have a Chapter 7 referral that would be structured in a somewhat narrow sense with respect to the target of investigations and prosecutions. Obviously, that referral would not be able to include the Assad government because Russia would never go along with that, so you have to be realistic about this. But it does seem to me that there is an opportunity there whereby the ICC could actually take on this non-state group over several jurisdictions with a special referral by the Security Council. But you would have to concede that all of us who are academics with respect to the ICC and civil society, that this would be a referral that would be somewhat unconventional with respect to the scope of personal jurisdiction within the referral, as opposed to a geographical, open-ended opportunity for the ICC to go after anyone committing atrocity crimes on that particular territory that's covered by the referral.
Thank you. Any other? Well, I think we're reaching our endpoint, although obviously we could go on and on and on. It's such a fascinating conversation, and I think just the comments of our panelists demonstrate so concretely and profoundly the value of having a dedicated team and office at the State Department to advance global criminal justice. So please welcome, join me in thanking our distinguished panelists for their service, for their wisdom, and let's hope that the small but mighty office of GCJ continues on into future decades. Thank you.
Thank you.
Well, welcome everybody to this panel on the International Criminal Court. And before I'm David Luban. I teach here at Georgetown Law. I teach international criminal law, and I would like to welcome my students who are here as well. Before introducing our very distinguished panel, I want to begin just by explaining what the International Criminal Court is, because it's something we have all heard of, but not everybody knows what it does or how it works or what its built-in limitations are. So what is the ICC? It's the world's only permanent tribunal for trying the world's most serious crimes. It sits in a gleaming new building in The Hague. It was established in 1998 by the Rome Treaty, and which today has 124 parties. It went into operation on July 1st, 2002. Unlike some of the other international tribunals, it was not created by the United Nations Security Council. It was actually a joint product of the member states, so the states that joined. Now, even though by now 65% of all the countries in the world are members of the ICC, there are some of the biggest countries have not joined, and that includes the U.S., China, Russia, India, Pakistan, and Indonesia, which are the half-dozen largest countries by population. Now, the ICC is designed to bring to justice perpetrators, high-level perpetrators of 4 what are called core crimes. These are the crimes of genocide, crimes against humanity, war crimes, and the crime of aggression. If that clause of the Rome Statute is activated, and we'll be talking a bit more about that today, it was on the books, so to speak, from the beginning, with a delay until the parties could agree on what exactly the crime of aggression consisted of. Now, there are two crucial facts that you need to know about the ICC. The first is that it is a limited jurisdiction court, and the second is that it's founded on the principle known as complementarity. And let me just say a few words about each of these. First, the jurisdictional limits. I just mentioned that the ICC's subject matter jurisdiction is the four core crimes that I named. So terrorism, not. International trafficking, not. Conceivably, the states parties could bring those under the ambit of the ICC at some point in the future. But as it is, it's just limited to the core crimes, and then what you might call ancillary procedural crimes like obstruction of justice in the course of investigating the core crimes. Second, it's got a temporal limitation. It can only take on cases after July 1st, 2002, when it went online. And if a new state accedes to the Rome Treaty and joins the ICC, then without special arrangements, it can only handle cases involving that state after it has joined. Third, it can only exercise jurisdiction over crimes that are committed on the territory of an ICC member state, a state party, or by a national of the ICC, of a state party. Now, that's why the ICC may not be able to go after crimes that are committed in Syria, because Syria is not a state party. Now, it can go after perpetrators from states that are not states parties if they commit their crimes or their alleged crimes on the territory of a state party. And that's a provision that has drawn some complaints from non-state parties, and it was an issue that very much concerned the United States. Now, there is one exception to this limitation of territorial and nationality jurisdiction, and that is when the United Nations Security Council refers a situation to the ICC. It can refer situations that take place in any UN member state. And that's, for example, how the Darfur cases came before the ICC. Sudan is not a state party. It's not a member of the ICC, but the Security Council referred it. Similarly with Libya. So those are the jurisdictional limitations, and I think that it's very important that everybody understand that those are wired into the Rome Treaty itself. That's important because oftentimes we see headlines talking about how the ICC is just not doing what it should be doing without the realization that it's a court of very limited jurisdiction, so that its hands are tied ex ante. Now, the second concept is complementarity. Complementarity is a fancy word for a very simple idea, and that is that states, the member states, are the primary enforcers of the laws against the core crimes, and the ICC is only the secondary enforcer. So the states get, so to speak, the first bite at the apple. If they are investigating and prosecuting crimes committed by their nationals or on their territory, then the ICC can't take the case. The case is, to use the official language, inadmissible. In other words, the ICC doesn't exist to displace states as enforcers. It exists to complement states as enforcers. Now, the final limitation on what the ICC can do that I want to mention is what's called the gravity threshold. The ICC exists only to try grave cases, and there is no magic formula about what makes a case a grave case. But cases that are one-off or small-scale events will, in most instances, not be over the gravity threshold, and therefore the ICC will find that those are also inadmissible. Now, how do situations get in front of the ICC? I mentioned one mechanism, and that is that the UN Security Council can refer them to the ICC. There are two other mechanisms. First, any member state can refer a situation to the ICC, and that includes states that refer themselves because they have a problem that they don't think that they're capable of addressing themselves. And in fact, the first cases that went to the ICC were all self-referrals by states. And finally, under certain carefully crafted safeguards, the prosecutor can herself initiate an investigation on her own in the law Latin that international lawyers are so in love with. This is called proprio motu, on her own motion. Now, in any event, no matter which of these three routes a case or a situation comes to the ICC, what gets referred are entire situations and not specific cases. And then the prosecutor, after investigating, will decide which cases that grow out of this situation will be the focus of the court. And there's an obvious reason for situations, not cases. It would be a bad idea to allow a state to refer specific cases that its enemy crimes that its enemy has committed, leaving its own crimes unreferred to the court. So it has to refer the entire situation, which means that if there's a conflict going on, it's subjecting itself to the same kind of scrutiny that its enemy will get. Now, the ICC cases are big, they're complicated, they're very difficult to investigate, and as a result, there haven't been many of them. Currently, the ICC has before it or has already finished 23 cases. Most of these 23 are currently in the pretrial phase. There are 4 actual trials going on in The Hague right now. 5 cases have been tried to a verdict. There are 4 convictions and 1 acquittal. And 4 cases have been closed for one reason or another, and probably the best known of these was the Kenya case, which the previous prosecutor initiated using his proprio motu powers. And the current prosecutor, Fatou Bensouda, announced about a year ago that she was closing the case because it was impossible to get enough evidence to proceed. And she issued a statement saying that because the government of Kenya had not been cooperating, she was unable to do the fact investigation. And significantly, this was a prosecution against the president and vice president of the country. Now, how about other situations that the court hasn't taken up yet but is looking at? There are 10 situations that are currently being investigated. One of them is Georgia. The other 9 are all African cases. There are another 11 cases that are at a still earlier stage, the stage of a preliminary investigation, which means that the prosecutor's office is looking to see whether to launch a formal investigation. And those include some cases that might be very controversial. Afghanistan, which is a state party to the ICC, where U.S. military activities in Afghanistan are being scrutinized. The UK's activities in Iraq are being scrutinized because the UK is a state party. Colombia and Palestine, all of those are very, I think, very high-profile and controversial preliminary investigations. Now, the last thing I want to mention before turning to our panelists is that something that everybody who reads the newspapers and follows this knows, which is that there's been particular friction between the ICC and Africa, and Professor Jallow was going to particularly speak to that. The fact is that all of the current cases come out of Africa. Now, there's no secret that many African leaders have found that to be, at best, irksome, and at worst, showing a real problem with the way that the court operates. Now, some of the reasons that these cases are in front of the court are very straightforward. Several African states referred themselves, and 2 African states were referred by the UN Security Council. So these were, so to speak, non-optional for the court. But there is at least a perception problem. Now, this past year, 3 African states announced that they were quitting the court. These were Burundi, which was potentially a target for the court, South Africa, and Gambia, which is the home country of the prosecutor. But then there was a change of governments in Gambia, and the newly installed president, Adama Barrow, has changed course and announced that Gambia won't be quitting the court. And recently, very recently, a South African court has held that President Zuma actually didn't have the constitutional authority to bypass Parliament and pull South Africa out. So it's not at all clear that South Africa is going to quit. But this is certainly a moment of significant tension. Now I'd like to introduce our panelists. And I'll do it in alphabetical order. You have their full bios in the program, and since they are distinguished people with long bios, I'm not even going to touch anything but their bare description. John Bellinger is a partner at Arnold & Porter Case Scholer and was the former legal advisor of the U.S. State Department and the former legal advisor to the U.S. National Security Council. Richard Dicker is the director of the International Justice Program of Human Rights Watch. Charles Jallow is a professor of law at the Florida International University, a member of the International Law Commission, and an expert on African relations with the ICC. My colleague, Jane Stromseth, is professor of law here at Georgetown and is the former deputy to the ambassador at large in the Office of Global Criminal Justice during the Obama administration. Jennifer Trahan is a professor at New York University Center for Global Affairs, and John Washburn is the director and convener for the American NGO Coalition for the International Criminal Court. And the way that we are going to conduct this is that I'm going to throw out some topics for our panelists. As you see, we have a large panel. Not everybody is going to speak to every topic, but we will just try to start the conversation going. And the first question that I want to throw out is, how should we assess the ICC's impact thus far? Is there any good empirical information on this? And I want to start by asking Jane if you would comment on this.
Thank you. Thank you so much, David. Yes, the ICC is making a difference in advancing the fundamental goals of countering impunity and contributing to the prevention of atrocity crimes, and there is some interesting empirical evidence on this. What I'd like to do is just briefly, because I have to be brief because we have so many panelists and I want to hear from everybody, is just sketch 4 different ways to think about the court's impact that have some empirical basis. The first is the court's track record in actually bringing people to justice. It's important to have a successful track record of fair trials and convictions if the court is going to help to end impunity and help to prevent atrocity crimes. And as David said, although the number of completed cases thus far is relatively short, there have been some very, very important trials, judgments, and convictions. Just to mention a couple, Thomas Lubongo was convicted of the war crime of enlisting and conscripting children under the age of 15 and using them actively in hostilities in the Democratic Republic of the Congo, the DRC. Just last year, John Pierre Bemba was found guilty of crimes against humanity and war crimes, including murder and rape, in the ICC's first conviction under command responsibility and for sexual and gender-based crimes. Also, last year in the El Mahdi situation, or the Mali situation, El Mahdi was convicted after pleading guilty to the war crime of directing attacks against historic and religious buildings. So these are some important examples of cases before the court that have led to guilty verdicts on very, very fundamental rules of international humanitarian law. In addition, there are a number of important trials underway, and I don't have time to talk about all of them, but let me just mention that the Lord's Resistance Army leader Dominic Ongwen who's charged with conscripting and using child soldiers, as well as crimes against humanity that include murder, sexual slavery, rape, and forced marriage. That case is currently before the court, along with a number of others. So there is a emerging track record of successful cases and convictions that are very important to the court's core mission of combating impunity. But it's not only a question of what happens in The Hague, it's also a question of engagement and outreach with victims and affected communities, which is something that the ICC focuses on, because it's important to give these communities a sense of a stake in the ICC's work and demonstrate that justice is being done. And there's, I think, a lot of important work being done in this engagement and interesting empirical studies of this, which I could talk more about if time permits. A second way to think about the court's impact is its role in catalyzing domestic action in pursuit of justice and accountability. And as David explained, this intended effect is built into the Rome Statute through the principle of complementarity, the idea that you give the territorial state the sort of first chance to do justice and try to build up domestic capacity for justice. And there are different ways to think about complementarity, and my colleague Richard Dicker is going to talk a lot about this and the empirical evidence, so let me just say a very few brief words. One form of complementarity is responsive or defensive complementarity, where the ICC may catalyze a defensive response in states that are trying to deflect the possibility of ICC jurisdiction. There's also what you might call positive or proactive complementarity, which involves the ICC working often cooperatively with states to help assist domestic accountability efforts. And some examples of this include in Guinea, in the Central African Republic, and elsewhere. And I think these catalyzing effects that the ICC is having in prodding and encouraging and sometimes directly cooperating with domestic prosecutions is another very important way to look at the court's impact. A third way to assess the court's impact concerns the deterrence and prevention of atrocity crimes. Is the ICC helping to deter atrocities? And this, of course, is very difficult to assess and will depend on many factors, including the nature of a conflict, the nature of particular groups. And one only has to look at the devastating violence in parts of the Democratic Republic of the Congo or the Central African Republic to realize the enormity of the challenge. Also, the ICC's dependence on states for cooperation and access and resources also influences its ability to have any kind of constraining or deterrent effect, particularly in situations where a country may not cooperate and may actively obstruct the work of the court. So it remains early to say what impact the court is or will have in deterring atrocities, but I have no doubt that some people are alive today because of a deterrent impact of the ICC. A brave Catholic nun named Sister Josephine in the Central African Republic personally saved the lives of several Muslim civilians who were sheltering on the compound that she and a priest were operating. And when some of the militia members grabbed and tried to take away, to no doubt certain death, some of these civilians, she stood up and she said, "This compound is under the jurisdiction of the ICC, and if you take these people away, you're going to The Hague." And the militias released the individuals. So we have at least some anecdotal evidence that there is some deterrent effect. But beyond anecdotes, political scientists have really gotten interested in this issue of deterrence, and what they've found is that whether the ICC has a deterrent effect it really depends. It depends a lot on the type of actor, the motivations of the actor. Some state actors, some rebel groups can be deterred both through the threat of prosecution and through something called social deterrence, the broader sort of social mobilization of pressure against atrocities. And of course, actors who are concerned about their legitimacy in the international community, or who depend on resources from other states, or rebel groups that aspire perhaps to create their own state and therefore need legitimacy and support, are more likely to be deterrable than others. So it's a complicated picture, but there at least is some evidence that at least in some circumstances, there is the possibility of a deterrent impact. Fourth and finally, another way to think about the court's impact is its empowerment of civil society around justice. The ICC is a galvanizing symbol of justice, notwithstanding its many challenges and limitations. It's a convener. The annual Assembly of States Parties meets annually, bringing together hundreds of civil society advocates and NGOs from around the world. And any of us who've been to those meetings can attest to the number of advocates that gather, that network, the side events on justice issues of the day, the reports, the documentation. So it serves as a way to bring together and catalyze civil society work in support of justice. And a number of scholars, political scientists, have actually analyzed something that they call unintended positive complementarity. And what they have found is that in countries that are party to the Rome Statute, where the court has opened up investigations, there is a correlation with an increase in human rights prosecutions in those countries. And what's interesting about this is they argue that the courts, the fact that the country signs up to the Rome Statute gives the NGO coalitions a basis to advocate and mobilize and scrutinize government conduct when it falls short of the standards in the Rome Statute. And that gives some space for the civil society advocacy that's having some of these perhaps unintended effects. So those are just a few examples of ways to think about the court's research. We're still early, I think, empirically in looking at this, but I'll just stop there to say that there's at least some promising examples of very concrete effects.
Richard, what would you add to Jane's account here?
Yeah. Thanks very much. And I can't start without thanking Jane, Patrick Griffin, the Law Center for convening this session. And not only on the basis of the fascinating conversation we got to listen into this morning of the former ambassadors of the GCJ, but also, frankly, it is so timely to have this conversation today. So many thanks for the far-sighted vision that brought us together. What I want to add to Jane's comments, and David, you referenced it in terms of complementarity. And we, as Human Rights Watch, are strong supporters of the court, but we are also constructive critics where we see shortcomings in important policy and program. Most recently, we've been conducting research in 4 ICC country situations where the office of the prosecutor is in that process of preliminary examination, whose purpose, or the purpose of which, is to decide whether or not the prosecutor will in fact move on to open a full investigation. And we've looked at the impact of the office in this phase in Colombia, in the Republic of Georgia, in the United Kingdom, as well as in Guinea. And the conclusions that we've come to, I mean, to state the obvious, the office of the prosecutor, when it engages in positive complementarity, a term which really came into being, I believe, around the time of the review conference in Kampala in 2010. But overall, the office of the prosecutor's engagement with national authorities in this preliminary phase to bolster their own, that is, domestic authority investigation and prosecution of these ICC crimes, it faces a steep challenge in moving that ball forward. But from our research, we are confident that when the office engages properly, it certainly has incremental, positive impact in moving domestic prosecutions or investigations and prosecutions forward. And a word on this, the complementarity effect is all the more important nearly 20 years after the completion of the Rome Statute, because we've seen the limited docket. I think there was reference to 5 accused from the Democratic Republic of the Congo. The ICC is going to have, unfortunately, a limited docket. Another reason this effect is so important has to do with the proliferation of crimes that need adjudication at fair trial. So this issue of ICC Office of Prosecutor effect takes on, in the world of 2017 and the foreseeable future, greater importance and significance than it had, I believe, initially. And just to lay out a few points and wrap up, we've seen that the Office of the Prosecutor has been more effective in situations where the crime base is limited. And one could contrast Guinea with Colombia. We've seen, not surprisingly, more effect of the office where there is some public demand in country, specifically among civil society organizations and the media. 3, where the Office of the Prosecutor is able to work in partnership with other actors, that multiplies and amplifies the office's effect. Those actors include the United Nations, its various agencies, special rapporteurs appointed by the Human Rights Council, as well as individual donor states attentive and engaged in the countries. And finally, and most difficult, with most difficulty, the prosecutor's office has greater effect where its role as a sword of Damocles, if you will, that is a unique international actor that, unlike states, unlike the United Nations, can actually take up prosecutions if the domestic authorities fail to do so. It's in those situations we found that the office's effect in catalyzing national prosecutions is greater. Let me stop.
Well, thank you. I'm going to turn now from what the impact of the ICC has been so far to a question that is very much on everyone's mind, and that is, what are the challenges that are facing the ICC now? Do we sometimes have expectations for what it can do that are too high? Is its capacity too limited? Sometimes capacity is a polite word for money. Does it have any issues of legitimacy that it's confronting? And I mentioned earlier that the one that seems to be uppermost, at least in the headlines, although I think not necessarily uppermost in the minds of people who are deeply involved in the process, are the current tensions between the ICC and Africa. So I'd actually like to, I suspect everybody on the panel has something to say about the challenges. And I'd like to start with Charles Jallow.
Thank you. It's a pleasure, Jane, to be here, and I join Richard in complimenting you for a job well done. It was quite interesting to hear all the former ambassadors essentially make the case, and I think it's an even more important case that we should make in this particular environment. Hopefully the conversation would continue in the direction that we want it to go, which is to amplify the standing and the role of the United States in pushing accountability for international crimes globally. With respect to a question, David, you mentioned at the opening a significant tension between the ICC and Africa. And I'd like to start by clarifying a couple of things that are very important. One is, oftentimes when we think about Africa, we, of course, put in one basket a whole host of countries. I mean, you're looking at, if you think about now the membership of the African Union, 54 countries that are very diverse, that have very distinctive aspects to them in terms of cultural languages and so on, and obviously at the level of national interest. So the panoply of countries that we're dealing with in one basket is quite extensive. And of course, there are governments in Africa and there's civil society in Africa. So maybe to make a distinction there in terms of understanding the relationship between Africa and ICC. So primarily, my comments will be focusing on what African governments, especially within the framework of the AU, have been saying about the International Criminal Court, in contrast to the views of African civil society, which has been incredibly supportive of the idea of accountability for international crimes. And when you think about some of the examples that you gave earlier, I mean, these are led by civil society organizations. I'm thinking the work in South Africa by the Southern Africa Litigation Center around the al-Bashir issue in terms of the debate in the courts and even initiating an action in the domestic court. Before that, we had Kenyan civil society organizations attempt to do something very similar in the context of Kenya, basically saying that Kenya is a state party to the ICC. We hear that you are having a visitor who is an indictee of the court. Please plan to turn him over. They even won a judgment at the initial stage, and we know how that went. And in many ways, the contrast between the Kenya example and the enthusiasm of the civil society there compared to the South African example speaks to some of the challenges when you think about the role of the judiciary and an independent judiciary in particular, and how effective one's advocacy could be in one context compared to the other. So leaving those two preliminary comments aside, if you think about the Africa-ICC relationship, underscoring that I'm talking about African governments, underscoring further that I'm talking about African governments, especially within the framework of the AU, at the broadest level, one could caricature them for the purposes of the conversation here as one, concerns about legal issues, so legal concerns, and two, concerns that are more political in nature. If we start with the legal concerns, I think over the last decade or so, we've seen quite a bit of enthusiasm for the ICC, especially in the early days. So the examples of Uganda setting us off with the first prosecutorial self-referral that David mentioned as an option, which in fact provoked a big debate among international law academics as to whether self-referrals were anticipated at Rome. I mean, that debate is basically now out the window because we know that, yes, self-referrals seem to be part of the name of the game. Uganda showed big commitment to the court. It opened itself up to the ICC coming in, even though the manner in which the referral was framed suggested other motives, right? Because they basically, it seemed, were interested in having the ICC come and go after the LRA, the Lord's Resistance Army. Once that became not so much the only focus of the ICC, then we saw a bit of a change of heart there. But you could start from there and follow through all the number of additional self-referrals by African states that saw African states saying, look, we have a problem on the ground. We can't deal with it on our own, and we invite the International Criminal Court prosecutor to come in here and carry out investigations. And in doing so, countries in the region have been very cooperative with the ICC for the most part. But really, we had a big turning point, and that was the moment that the first prosecutor, Moreno Ocampo, announced that he was going to seek an indictment of President al-Bashir. And why is that important? Well, from the point of view of African states, they took the view that the intervention of the ICC at that moment in the context of the Darfur investigation was going to potentially jeopardize the peace that they had been working on attaining in Sudan. So essentially bringing to the fore the peace justice debate. So it really put the court in the crosshairs to be in Sudan from the point of view of African states. And it was interesting when you go back to the AU decisions, they always emphasized that they were not against accountability in Sudan. They were concerned about the sequencing of justice in Sudan. So they were worried about the timing of the prosecutorial actions. And they worried about those because they felt that the conditions on the ground were too delicate. We've seen this argument play out in a number of other instances. Others that are less credible, where this argument was raised. If I think about Kenya, you mentioned Kenya earlier. So one could kind of put all of that, those objections in that basket of the debate about peace versus justice or peace and justice, and in particular the timing of prosecutions. Those are one set of concerns that one could identify. What do we do in the statute to deal with them? Obviously, we have, for the technicians in the room, Article 53, the interest of justice provision. I think Human Rights Watch had taken views on this. We even have an official policy paper on the interest of justice in terms of what the ICC OTP, the Office of the Prosecutor, sees as its role vis-a-vis these kinds of questions, essentially saying these issues about sequencing belong elsewhere. They're not within our domain. We go after, if we have evidence against somebody, we'll go after them. And you go sort these kinds of things, if you want, at the Security Council using Article 16. The political mechanisms, go over there and deal with them there. I think that perhaps simplified it too much. And if you dial forward to where we are today, if we had engaged the question seriously early on, we might have been able to avert what later on became this decision by a number of African states that they will in fact express their dissension with the court by withdrawing. So I think there are some lessons, friendly criticism from friends that we could join in the Human Rights Watch approach. You can be constructive in the way you criticize the court. It's a new institution. It's not perfect. After all, it's a human institution. But then you can also be more open. And I think today, compared to where we were some years ago, the court is definitely more open to the idea that, look, we are open to constructive criticism and to revisiting some of these questions. I don't know, others in the room may be aware, if there's a desire on the part of the Office of the Prosecutor to revisit the policy paper on the interest of justice. I think that may be a wise move, provided obviously that the court balances the imperatives. Nobody's going to argue that we should give a free pass to individuals allegedly involved in crimes, but I think to recognize that the provision was included in the statute for a reason, to give the prosecutor some wiggle room to play in circumstances that are very complicated. So I think the legal issue that I would focus on as in really meriting engagement from the point of view of the African concerns, especially as expressed by the AU. So how do we deal with this reality that the court is involved in live conflicts? You can compare that to all the ad hoc tribunals that came, going back to Nuremberg. Most times, with the exception, the slight exception of the Yugoslav tribunal, the conflict had ended. Whereas with the ICC, the court is brought in when the conflict is live. I mean, Sierra Leone had a conflict, but it was in the dying days at that point. Rwanda, the genocide had ended. As I said, in Yugoslavia, we saw the turn. We knew that peace will come at some point. So unlike all of those experiments, the ICC is going to be involved on the front end when the conflict is ongoing. I think to engage seriously with that question would be to do something important for the court, not just for Africa, for the success of the regime that the court anchors, which is a regime of accountability for those bearing greatest responsibility for international crimes. There are a number of other smaller concerns about the law, issues that African states had around, for example, the role of the Security Council, especially after the Security Council failed to give the deferral that African states were looking for, and we can come back to those maybe later on. I see a range of those questions, issues around cooperation, issues of immunity that have been raised, this idea that, look, we are, in the case of South Africa, for example, we are a state party to the court, but the fact that the court has requested us to surrender a sitting head of state put us in a position of legal difficulty because customary international law is over there, and that doesn't evaporate because we have the ICC regime. And there are ways you can get into all of that.
And this is referring to a visit that President Bashir made to South Africa when the government, I think it's fair to say, stalled so that he could get out of the country before it had to turn him over.
Yeah.
But I can't forbear from asking you one predictive question. Do you think South Africa will stay in the court or not?
Oh, boy. Your guess is as good as mine, I guess. It will be the only response. I mean, I know officially, formally today, they have written to the Secretary General and said, okay, we are withdrawing our request to withdraw, right? That is before the Secretary General as a depository, formal depository. I don't know whether politically there is a movement, I think, within the ANC. There definitely is a movement of those who are committed to withdrawing South Africa are still there. But of course, now the process has become more democratic. There's a parliamentary committee that has invited civil society and others to input into the process of whether it's a good idea to withdraw. So I think the chances are diminishing, so I would say. I think I'm more hopeful about the picture today compared to where we were when South Africa announced the withdrawal.
Thank you. Jennifer Tran, what do you see as the biggest challenge to the court, aside from what Charles Jallow has just spoken about?
Sure. Well, let me start by commending Jane for hosting us. Unfortunately, I thought of quite a few. One of the first is to show the ability to prosecute state actors. So I think the court has been more successful going against rebels and those out of power. It's had some real glaring setbacks. If we look at the Kenya and Sudan situations, in the long run, I think it needs to demonstrate this ability. And this is related to the inability to get some of its outstanding arrest warrants executed. So this is an issue of cooperation. Now, where a situation stems from a Security Council referral, the Security Council ought to be taking this issue up. It generated the Darfur situation, but somehow it has jettisoned the responsibility. So we have all those warrants outstanding. Then when an indictee travels into a state party, unfortunately, we just had President Bashir go into Jordan. So Jordan is a state party. Then this is more, clearly the court's province and then the ASP's province. And I think the court in the long run has to go back to some of the lessons from the former Yugoslavia. And surrenders didn't happen until there was real leverage put, until the U.S. conditioned funding assistance and the EU conditioned EU accession. So I think we have to go beyond condemning non-cooperation to somehow having real teeth, because in the long run, it won't work for the court if it has so many outstanding arrest warrants. I expect John will talk more, so I'll just touch on funding. The state's parties need to fund the court. It is at its busiest ever, with 10 pending investigations and 10 pending preliminary examinations. We have to be careful of the ASP's role also in terms of preserving the independence of the court. The ASP is, of course, a political body with this management oversight role. Complementarity has already been alluded to by a couple of speakers, and this is not so much about making the ICC function, but the ICC is part of a system of international justice. And in the long run, I think if the system doesn't function, there will be cynicism with the ICC. How come you're only prosecuting 5 for Eastern DRC? So there's a lot of work done in complementarity, but it's not really coordinated. There is no central control over this. There is no great ASP commitment to fund the ICC to do this.
Assembly of States Parties.
Assembly of States Parties. in the long run, I think making complementarity really work is a big challenge. And I'll just close with saying maybe the greatest long-run challenge is bringing the non-state parties into the court system. Not only stopping the withdrawal, so far it looks like of the 3 that were announced, we only have 1 right now happening. But in the long run, I think we want to see some of the non-state parties who are standing aside from the system of justice, committed to prosecuting only the gravest atrocity crimes, join the system, because if the world is divided into the have and have-nots, those who accept that atrocity crimes need to be prosecuted and will stand behind the commitment that if they don't do so themselves, they agree their nationals can be tried by the ICC. We have to somehow bring more countries into the fold. And I think for the court, the challenge is just showing that it's a responsible, effective, judicial institution that then convinces our outlier countries that it's better to join the system than to stand aside.
Yeah, thank you. So you mentioned money, and I'm going to ask John to talk a bit about the financial challenges. And I should just preface this by saying that I looked at the map of who's paid up among the states' parties and who is in the situation of, how to put it, the check is in the mail, and who is in the red. And I was a little chastened to discover that the sky blue of fully paid up, there is not that much blue sky among the states' parties, and there is a lot of orange check in the mail and quite a bit of red, which I read as hopelessly in arrears. And I'm wondering what your reaction is to this challenge.
Okay. I'd like to start by, if you don't mind, addressing the question of challenges of unrealistically high expectations, and then I'll get into what you've just addressed under the heading of limited institutional capacity. Very quickly on challenges. There is, on unrealistic expectations, many state parties and others, and there is some feeling about this in the court as well, want the court to address a much wider range of defendants than can be probably justified by the Rome Statute. This is a particularly critical situation for the court now because it has matured to a full workload now, which has a relationship with the budget problem that I'll describe in a moment. The court has done its best to speed up cases, but there are demands for speed that go beyond what can be expected in a true international criminal court. The law has its delays, and some of those delays are simply not possible to reduce. There are people, quite a few, who want the court to impose much longer sentences. They want to see people going away for life, particularly when you think of the horrific nature of the crimes that are being tried. That isn't going to happen on the record. The court is very careful about how long its sentences are, and even for those defendants who have committed the most atrocious of crimes, the sentences have not been as long as they certainly would be, for example, in a lot of criminal courts in the United States. The issue here is that the court feels that the act of conviction, rather than the length of sentences, since there can be no sentence which is conceivably adequate to what these people have done, it's the fact of conviction that matters most, and what it says to victims. There is the problem of unreasonable expectations about reparations. This has now come to a head because we now have 3 orders from the court on the question of reparations. The funds are limited that are available for this. There is the question of shall they be individual or collective. There are unrealistic expectations about how those decisions will be made and what they will be, and also how fast the Victims' Trust Fund can get reparations out to people. Finally, we've already discussed the question of enforcement, but I would like to just highlight that in a connection with enforcement, there is the Rome Statute's requirement, which has already been discussed, that the prosecutor must address all sides in a given situation. The Office of the Prosecutor has found it very difficult to do that. In Uganda, for example, we have heavy action against the Lord's Resistance Army. The Office of the Prosecutor has not done very much to deal with clear crimes for most of us by the Ugandan Defense Forces. On the question of limited institutional capacity, there are two aspects here that are interrelated that I would like to address. There's the question of the budget, and there's the question of the Assembly of State Parties. You can't really divide these two. It's already been made very forcefully that there isn't enough money, and that's true. I just want to particularly demonstrate that with a couple of quick numbers. The court asked in the last Assembly of State Parties last November, asked for 147,250,000 euros. After deductions for payment on a loan, which means that that money was not available to be spent by the court on its activities, it wound up with 141,600,000 euros, which is equivalent to almost $146 million. That is a 1.9 increase over the preceding year, at a time when the court went into full overdrive on dealing with an expanding workload, both in terms of preliminary examinations, investigations, as well as trials. That obviously is inadequate. It is also very clear that the ICC asked for too little money up front, and it got even less. The reductions are going to particularly fall hard on the operations of the Office of the Prosecutor in the field. It's going to fall on the conduct of trials, particularly the question of assistance to victims and into translation. And this is going to be a very serious situation for the court unless state parties can be brought to get away from zero-based budgeting and recognize the real true needs of the court, and the court has got to be much more emphatic in doing that. Now, there is a real reason why the court has trouble doing this. The Assembly of State Parties has only one standing body. That's the Committee on Budget and Finance. It's as though the House of Representatives in the United States only had an appropriations committee and no other committees. Now, I don't want to disparage the work, the very good work that has been done by...
Sometimes this could sound like a really nice thing.
It's not nice. It's not good for the
I'm not
court.
talking about the ASP either.
Yes, okay. Well, the people in the ASP were very frustrated about this as well. I don't want to disparage the very excellent work that the network of task forces, working groups, and so forth that have been set up and exist and that work on substantive issues before the court have done. These are not, however, they don't have the clout of a standing committee. They send reports to the Bureau. The Bureau, for those of you who don't know, consists of the Secretariat of the Court plus a selected group, a kind of executive council of member states. These reports go to the Bureau, which then forwards them on to the Assembly of State Parties. That is a very valuable, but it's a less forceful contribution, a much less forceful contribution than is the case where a standing committee speaks to the Assembly of State Parties, a standing committee that is composed of member states that serve on that committee for long periods of time. I recognize that the Committee on Budget and Finance is supposedly composed of independent experts, but they are all proposed and nominated by member states. So the distinction is a little bit thin. This means that the court has no other committees to go to fight for it on particular aspects. The registry needs a standing committee to deal with its problems. The Office of the Prosecutor needs a standing committee to work with its problems. The the courts, not in terms of cases, no incursion on judicial independence, but the court needs a committee which works on the administrative and management problems of the chambers. This fundamental flaw in the structure of the Assembly of State Parties is a major reason for the failure of the ICC and its fear to make its full case to the Assembly of State Parties. Thank you.
Oh, thank you. John Bellinger, from where you've been sitting, you've been watching the ICC since, I expect, its inception, and maybe even before. What do you see as the biggest challenge facing it right now?
You know, David, I think what I'm going to do is to reserve the majority of my time for something that's mostly in my lane, which is the relationship between the U.S. and the ICC. I will say about 2 sentences on this, which are, again, sort of in my lane, to simply say there are so many challenges, but one of the challenges for the prosecutor, who is just squeezed, I think, in a vice right now on this issue, are what to do about the preliminary examinations of the U.S., the UK, and Israel. And those are many of the challenges that were laid out, such as Jennifer saying, well, what are we going to do about Russia, China, and the United States? Those are very long-term challenges. What the prosecutor is going to do in the next couple of weeks or months with respect to the U.S. and the UK are immediate challenges for her. She's obviously got people telling her, you're independent, you've got to go after the U.S., you've got to go after the UK, you've got to go after Israel. On the other hand, if she does that, particularly with respect to the U.S., but to a lesser extent with the UK, she will poison any possible relationship that the court could have with the U.S. or the UK. So it's just, she's in a very difficult position as a challenge, but I'll hold the rest of my remarks.
And well, we will certainly, I suspect that you're going to circle back to that when you talk about the U.S. relationship with the ICC. Richard Decker, do you have anything that you wanted to add as a challenge that hasn't come up so far in the conversation?
I'm staggering under the list of challenges, but I do. Thank you, David. The challenge that strikes me overall, and particularly as we approach the 20th anniversary of the completion of the Rome Statute, which will be in July 2018, is the imperative for this court, as was the case for the ICTY, the ICTR, the Sierra Leone Special Court, etc., to receive the political support, the diplomatic backing that it needs from its states parties and others. And you see an ebb and flow of that over the last 15 years. But I think the world situation that the court is working in now requires greater backing. John was talking about the budgetary implications of the Assembly of States parties. This court needs more political muscle supported by or supplied by its states parties. And just to end that on a positive note, I was intrigued by Charles's presentation and think that in the experience of the antagonism that has existed going back to 2009, and Charles hit the nail on the head about the warrant against Omar al-Bashir, president of Sudan, as the trigger for the backlash, that it's so instructive to look at the last African Union summit, where the headline was AU adopts strategy for mass withdrawal from the court. The reality was, prompted by the possible withdrawals of 3 African Union state parties, 16 AU member states, also ICC African state parties, entered reservations into this adoption of a strategy. First time we had ever seen that. And to me, I think there are invaluable lessons to mine in terms of the way those African states worked, the way support from the likes of Canada, Denmark, the Netherlands contributed to that, and that will be essential for the period ahead. So diplomatic support right up there on challenges that need to be addressed.
Thank you. And Jane Stromseth, we've heard a lot of challenges. Did you have any that you wanted to add?
I just want to say, I think a big challenge is what I call the expectations dilemma, which is there are so many high expectations of the court by civil society in Africa and elsewhere who look to the court for the possibility of justice. Sometimes they do that when there isn't jurisdiction and isn't a basis, but they often do look to the court. And if the court is going to have some of the effects I described, if it's going to be able to catalyze meaningful domestic accountability through complementarity, if it's going to be able to contribute in any way, in some instances, admittedly, maybe only some, to deterrence, if it's going to help be a basis for civil society mobilization, it has to have some success in its track record. And so on the one hand, you have these enormous expectations put on the court. On the other hand, you have all these constraints and limitations and lack of funding and diplomatic challenges and PE issues and so forth. So this gap between the expectations and the reality of what the court is able to deliver is really quite profound. And so that's a real big challenge going ahead. And I think it's important neither to overestimate or overstate what the court can or should accomplish or understate. And it's got to navigate that terrain in a way that I think is really, really deeply challenging.
Well, thank you. I'd like to turn now to the question that John Bellinger mentioned earlier, and that is the U.S. relationship with the ICC, how it's evolved, where it's headed, and you had a front row seat in both terms of the George W. Bush administration, where at least from my seat, far, far away from the stage, it looked like the first term was a very hostile relationship as the administration de-signed the Rome Treaty, and there was a pivot which I think happened maybe around the time that the United States became extremely concerned with what was going on in Darfur, and the ICC seemed like a plausible solution. But I would very much like to hear both your sense about how that evolved and also where you think it's going.
Thanks, David. Sometimes being in the seat was not just a front row seat, but sort of being in the hot chair. So the United States is about to embark, or the ICC is about to embark on a relationship with a fourth new U.S. administration. So I wanted to talk a little bit at the broad terms about the ebbs and flows of this history. There are a few people who know this quite well. The students may not know the history. There are a few things that I'm going to say that I think, other than maybe David Sheffer and one or two other people, don't know this because it was from the inside perspective. And we know the adage that those who are not familiar with history are doomed to repeat it. And one of the things that I'm actually concerned about is that the Trump administration will start from an ideological perspective and not be aware of the changes that were actually made in the Bush administration after some mistakes were made in the first term. So, particularly for the students, just as a reminder, the broad sort of mythology was that, well, the Clinton administration was for the court, the Bush administration was against the court, the Obama administration was for the court, and the Trump administration is going to be against it again. And that's just not really true on a whole lot of levels. Despite David Sheffer's just extraordinary efforts, and I actually did have a front row seat for that because I was the Justice Department at the time watching, as the students presumably know, the United States supported the treaty but ultimately voted against the treaty. Only one of 7 countries in the world to vote against the Rome Statute. despite David's efforts, largely because the Defense Department was against it, and so we voted against it. President Clinton then, while signing the Rome Statute, said that the treaty was so flawed that it was not going to be sent to the Senate. In the first term of the Bush administration, there was a good deal of hostility and suspicion of the court, but that then changed in the second term. I will say a couple of things. One, the American Service Members Protection Act, which was always blamed on George Bush as if it was sort of written by the White House, check your history here. This was actually drafted by people on the Hill. I was the White House negotiator, busily trying to put in waiver authority so that it was, in fact, consistent with the executive branch prerogatives. I'm fond of reminding Europeans this, who always blame the Hague Invasion Act on President Bush. Remember that Hillary Clinton and John Kerry voted to invade the Hague before George Bush ever signed the bill. So, this was something that was basically cooked up on the Hill. I can tell you I spent a lot of time negotiating waiver authority into the American Service Members Protection Act. I'd also encourage you to look back at the speech that Mark Grossman gave in 2002 when the United States notified the court that we were not going to become party. Very soft speech that simply said there is common ground between the United States and the Rome Statute members, and I urge you to meet us there. And there is common ground, and I do hope this is something that the Trump administration will go back and look for that common ground. Unfortunately, in the first term, largely because of the dogged pursuit of Article 98 agreements and the unsigning, it did poison the relationship between the United States and the rest of the world over the court. In the second term, we had, as David said, a pretty significant pivot. I wrote a paper for Secretary Rice shortly before I became legal advisor saying, we need to get to a better position. We need to get to that common ground that Mark Grossman laid out. And she accepted that recommendation, and we worked on that throughout the second term to get to, I actually took this term from Javier Solana, to get to a modus vivendi between the United States and ICC parties. As you said, it started with the abstention on the Darfur referral on 1593, but the pivot really predated that. We were already trying to get to a place where we would be able to engage with the court in appropriate cases. The president began to issue waivers of the cutoff of counterterrorism assistance that was required under the ASPA. Secretary Rice famously said at a hearing that cutting off counterterrorism assistance to our friends was a little bit like shooting yourself in the foot. I then gave literally dozens, probably far more than that, of speeches, both publicly and then to our allies, basically holding out our hand to say, let's look for that common ground. Let's look for ways to work together. I publicly said, as did Clint Williams and others, that we're prepared to assist the court, work with Rome Statute members, that the court had a role to play. I gave a speech towards the end of the administration that said, let's work together on these things, that my former colleague John Bolton then promptly denounced in the Wall Street Journal. You can go and find this, in which he called my speech pablum, reflecting the yearning of the Rice State Department for acceptance by academics and foreign intellectuals, and that the fight would continue after January 20th. Well, he turned out to be wrong about that January 20th. I'm a little concerned about what January 20th he might be referring to. The same speech that John Bolton denounced as pablum, I have to say, Richard Dickern, I can remember this something like 10 years later, because it's one of the nice things Richard said about us. He said, this is a meaty speech. I can't believe this would have been given in the first term of the Bush administration. So
from pablum to meat.
From pablum to meat. So there really, at the time, it pained me because Europeans, I think, didn't see this pivot as it was happening, but it's now sort of seen more in retrospect. And the reason that I give some of that is part for the students to be reminded of the history, but more about not repeating the history. And I'm going to end with this point about, none of us know what to expect from the Trump administration on these issues. I think those of us who, would like to see the court succeed in the cases where it's doing important work, would like to see the Trump administration not declare war on the court. I think many of us are worried that it could. It hasn't done anything yet. The things that it could do are, obviously, it could cease being an observer to the Assembly of State Parties. It could cut off the assistance that has been either offered or provided or could be provided in those cases that the United States has previously acknowledged are important. It could step up criticism of the court generally for its coverage of the United States. It could seek new legislation of sort of ASPA plus. It could start trying to encourage more countries to leave the court. So there are a number of hostile actions that the Trump administration could take. I will be speaking out and writing and saying, look, don't do these things. Look at the pivot that we made in the Bush second term, where we felt that when the court is doing work that the United States supports that is important, we can have this constructive engagement, we can have this modus vivendi. But if the court ends up conducting an investigation of the United States, I just don't see that whether it was the Obama administration, the Trump administration, or the Hillary Clinton administration, I do not see how the United States can, while the Trump court is investigating the United States, have that level of cooperation. So I think that is an unfortunate choice that the prosecutor has got to make. Perhaps the Trump administration is going to declare war on the court anyway, for ideological reasons, but I would hope that the prosecutor will not make it easy for them by sort of waving that red flag in front of the bull. So we will see what happens in the Trump administration.
Okay. And ASPA is the American Service Members Protection Act, which, among other things, did authorize the president to use military force if necessary if an American national was in custody of the court, which is where the nickname Hague Invasion Act came from.
I'll tell you a one-liner on this, which I do not know to be true, although I believe it to be true, that when the new Dutch ambassador presented his credentials to President Bush in the Oval Office in the months after the president had signed the Hague Invasion Act, or the American Service Members Protection Act, and was so concerned because this was a sort of a big deal back in The Hague, that quite remarkably, because when presenting your credentials, you usually don't raise unpleasant issues. You just shake the president's hand and say, nice to meet you, Mr. President. But supposedly the ambassador did say, Mr. President, we really are very concerned about this legislation in which you said that you'd be prepared to invade The Hague in order to free Americans who are held there. And I am told that President Bush wrapped his arm around the ambassador and said, I wouldn't worry about it.
I can't help but earlier you had mentioned that there were the same kind of political storm that would arise if the prosecutor opened an investigation of the United States would also happen if there was an investigation of Israel. Do you want to elaborate a little bit about that before we move on to?
I want to make sure there's room for questions. It's hard to know if the prosecutor comes directly after the United States. It's very hard for the United States, as I said in the administration, just to say thanks very much, but we're also prepared to help you in these 4 other investigations. If the prosecutor advances the preliminary investigation of Israel's actions in Gaza to an investigation, the United States may have similar concerns. It's obviously not as direct a challenge to U.S. national security interests as an investigation of the United States, but there is a close relationship between the United States and Israel, and so you can imagine that there probably would be pressure inside the United States government. And as you probably can sense from my remarks, both in the Bush administration, certainly in David Sheffer's administration, in the Obama administration, there are always a variety of views on these things. I mean, there are going to be moderates, there are going to be conservatives, there are going to be people who are ideological, and people will have very, very strong views on these things, and they will have to get sorted out inside the Situation Room.
Thank you. Jay, you had the front row seat, or at least the third row seat, in the Obama administration. So,
Right. So,
what did you see that you're allowed to talk about?
so although the second Bush administration, as John correctly describes, did move and moderate its stance toward the ICC, it nevertheless did not participate, I think, in key meetings such as, negotiations or the ASPs and so forth. And I think when the...
That was a battle I lost.
Yeah, okay. Thanks for trying. But basically, when the Obama administration came in, and I think we talked about this in the panel this morning, there was a very careful interagency review of the U.S. relationship to the ICC that included all the major players, including the Department of Defense, and ultimately a deliberate decision was taken to engage more directly with the court and to support on a case-by-case basis and consistent with U.S. law, which does put some constraints, the court's work to ensure accountability for international atrocity crimes. And I think the Obama administration regarded engagement with the court, including participating in the negotiations at Kampala over the crime of aggression, and in participating as an observer delegation at the Assembly of States Parties, as a valuable way to both advance U.S. accountability goals and to protect U.S. interests. So it had this sort of multiple purposes. And one result, I think, at the Kampala negotiations is that there was a result that the U.S. very much sought, which was that non-state parties would not be covered by the crime of aggression. So that was an example where active participation was important to protect U.S. interests, but also to advance U.S. values. I would just like to highlight a few examples of the engagement and the case-by-case support that was the U.S. relationship with the court during the Obama years. So one was the U.S. actually regularly expressed support at the time for all of the investigations and trials in which the ICC was then engaged. Another example, it worked to actively support many domestic and hybrid accountability efforts that were complementary to the ICC. For example, the Special Criminal Court in the Central African Republic, which we'll hear more about in the next panel, is something the U.S. has worked hard to support. It's worked hard to support including meaningful accountability in the Colombian peace process, the Habre Tribunal in Senegal. There are just a number of examples where the U.S. worked to advance accountability in very concrete ways that I think are complementary to the ICC. Another thing, the Obama administration, during that time, the War Crimes Rewards Program was expanded to permit the offering of rewards of up to $5 million for information leading to the arrest and transfer of foreign individuals wanted by international courts. It was expanded to include the ICC as one of the courts where we could offer rewards. And as I understand, Joseph Kony and Mudit Shamora, two are currently listed as people for whom rewards are offered for their arrest and transfer. The U.S. assisted concretely in helping transfer Bosco Ntaganda to the ICC after he presented himself at the U.S. Embassy in Kigali, Rwanda. We also worked closely with the African Union, with Uganda and the Central African Republic to ensure the transfer of Dominic Ongwen to the ICC. So these were very tangible and concrete examples of support. And finally, the Atrocity Prevention Board, which we talked about this morning, was, I think, a systemic reaction and effort to address atrocities, hopefully early before they explode, and try to prevent them. All of this, I think, was part of a large and systematic effort to support justice and accountability in ways that had a constructive and pragmatic engagement with the International Criminal Court.
Well, thank you. And now about the ghost of Christmas future.
Yeah.
John Washburn, I know that it's very early on in the Trump administration, and the State Department isn't even fully staffed yet. And so I'm not sure how much that there is to say, but are you anticipating cooperation with the ICC? Or are you anticipating that your own job is going to involve gulping a lot more antacids now?
Well, I think it would be dangerous for anybody, and I'm not going to try it, to predict in any depth what this extraordinary administration is likely to do on any subject, and particularly on this one. We have had a few straws in the wind. The working group on the ICC, composed of NGO offices in Washington, which I co-chair, has done its best to try to figure out where we should go and how we should get ready to proceed with our advocacy or our defense of the court in the United States. We've had a couple of very thin straws in the wind. One of them is that there is a draft executive order which purports to cut back drastically on U.S. contributions to all international organizations, including the ICC. Now, the interesting thing about this is, of course, that the American Service Members Protection Act already forbids funding of the ICC. So, hey, buddy, you who drafted this thing clearly don't know anything about the ICC. The other straw we've had is that we have cherished certain hopes about how Nikki Haley might be as UN permanent representative at the UN on the question of the ICC. We have learned from the New York Times that she has appointed Peter Grove, who is a well-known critic and opponent of the ICC, to be a senior advisor to her. And so that is not a particularly, that's a disappointing situation for us to have to confront, and it probably is predictive of how the court will go. I join John Bellinger in thinking that the Afghanistan and Israel issues will probably be the wake-up call about the ICC for the Trump administration, which means that the Trump administration will achieve awareness about the court in the most negative possible kind of context. One quick look at where those might happen with the prosecutor. The fact that, as it was noted earlier, that she is delaying now in where she's going to come out on this will be is an indication that she realizes how tough this is, and she's trying to figure out a way to cope with it. One would hope that in a normal administration, if Afghanistan, she decided to proceed with a formal, full investigation, that the United States would immediately get going on complementarity and prepare a way for to demonstrate to the Office of the Prosecutor, and if necessary later to the judges, that the United States was ready, willing, and able to take care of any charges against Americans in Afghanistan, and thank you, we don't need the court to do that. I doubt somehow that this administration will do that. We're likely to find some other kind of strenuous response, not very well informed about complementarity or any other aspect of the court. Now, that's Afghanistan. Now, on the question of Israel, in some ways, this is a particularly difficult issue for the prosecutor to finesse. The thing that makes it difficult is that the main charge against Israel, which of course will include charges about activities in Gaza in all likelihood, but the main charge is the settlements. The Rome Statute, for reasons that David Sheffer has extensively discussed in his book on missing souls, the Rome Statute is highly specific on this subject, that it is a war crime to transport your people into a territory you occupy as a result of an international war. The 1967 war was clearly an international war. Israel did import its citizens, and most of the countries worth listening to in the world on this subject have emphatically declared that this was an illegal action, this was a war crime that fits the section in the Rome Statute on this subject. Those countries include all of the countries of Latin America. The EU has been particularly emphatic on this subject with a whole series of statements, declarations, and so forth. It is going to be very difficult for the prosecutor not at least to charge war crimes on the basis of the settlement. If she does not do that, her credibility and the credibility of her office is going to be in serious danger. On the other hand, we all recognize that what will happen in the United States if those charges are brought and Netanyahu is charged with being a war criminal. Frankly, bluntly, that's what would happen if there were charges brought about the settlements. I think our planning for advocacy in the United States is premised on the likelihood that at least there will be a charges brought, or a request for, I should say, a request for investigation, formal investigation on the ground in the case of Israel, and that we will have to deal with the fallout from that in the United States. Now, our planning in AMIC and those non-governmental organizations that we are working with, most of whom are members of AMIC, is that like many other non-governmental organizations, we will not abandon the field in Washington, and I will get back in a minute to what we will do in Washington, but we're going to go to the grassroots. In the case of the ICC, there are very strong reasons for doing that. The Chicago Council on Global Affairs used the Pew Forum to conduct a poll on American attitudes on foreign policy, something it does every other year. The consequences of that poll were that 73% of the respondents in that poll declared that the United States should participate in the International Criminal Court. I'm quoting, that was the question that they answered yes to. Now, I'm not being Pollyannish about this. This is a nice, warm, fuzzy feeling. It doesn't affect much the way people act politically. It doesn't affect most people when they get into the voting booth and throw that lever. It's our job to take that feeling and translate it into the kind of strong political action that we're going to need. Now, the very important one important form that can take is working with federal legislators back in their districts and states. It is clear that in the coming and present atmosphere in Washington, making representations to congressional and senatorial offices here is going to be of limited utility. We do get interest. We have had events, and we will continue to have events in which we will address Senate and congressional staff on the question of the ICC, and these are usually well attended. Their effect is diffuse and hard to gauge. But if you go into a senatorial or congressional office back home, you get the people in that office saying to the senator or congressman when they come back, gee, Senator, we've had a group of 12 of our most important non-governmental or other organizations here, somebody from the Lions Club, somebody from the League of Women Voters, come in a group and say that we want you to avoid participating in hostile legislation, or in particular, there's a bill up which calls for cooperation with the ICC in a particular situation in a particular country, and we want you to support it. That gets response. Now, why does it get response? It gets response in a number of ways. The obvious one is that the legislator wants to get reelected. Beyond that, there are lots of legislators of all political stripes and ideologies who hate atrocities. It is a very serious fallacy on the part of liberals to think that conservatives are indifferent to atrocities. It's not the case. Sometimes you'll have very unexpected, since we're in public here, I'm not going to go into names, but I have encountered, for example, a senator notorious for his extreme conservatism whose staff has spoken to me about his interest and support for the International Criminal Court because the senator is an evangelical, and evangelicals have run missions in Sudan for years, going back to the 19th century. This man believes that whatever he feels about international organizations, ICC action on atrocities in Sudan that his church has told him about is worthwhile and should be supported. We have a lot of that kind of unexpected support. You can get a Lions Club luncheon in Sioux Falls, South Dakota, up on their feet cheering with the right kind of speech to them about why the values of the Lions Club corresponds to what the court is trying to do.
John, I think I've got to keep one eye on the clock.
Okay,
here.
I'll conclude immediately.
Okay.
Okay. So we're going back to the people. We're going to use the support that we can develop in Congress to conduct our advocacy. We're going to continue to inform and advocate for the court across the country, whatever happens inside the administration.
Okay. Jane has told me that we can go on for 5 minutes past 1 o'clock, and I do want to leave time for questions, but there was one other issue that I had wanted to raise, and I'll ask for just one speaker on that. The ICC has at the 2010 Kampala negotiations, it voted to bring online the crime of aggression when 30 states parties had approved it, had approved those amendments, and we're up to 32 as of last December. So that that is now going to be an issue. And Jennifer, I'd like to ask you just to explain this, and then we'll pass immediately to questions.
Sure, yeah. Just to say, the actual vote whether to activate or not will be in December of 2017, so stay tuned how this one turns out. But let me just describe a little bit the basics of crime of aggression in case you're not familiar with it. A tiny bit of history, because I know we're short on time, but at the International Military Tribunal for Nuremberg, the judgment deemed crime of aggression the supreme international crime. And of course, the U.S. was a leading force behind Nuremberg, with Chief Justice Robert H. Jackson taking leave from the U.S. Supreme Court, leading the U.S. prosecution efforts. But then jumping forward, I'll do a real quick history, to 1998, the Rome Statute leaves this kind of placeholder in Article 5.2. It says, we believe this is one of our core crimes, but we have to first define it and define the conditions for the exercise of jurisdiction. We then go into a very lengthy negotiations period before the Preparatory Commission and then the Special Working Group on the Crime of Aggression, a time at which the U.S. did not attend these negotiations, even though, as an observer state, they were entitled to do so. And this was the formative time when we defined the definition. Then coming under the Obama administration, we continued with negotiations at the 8th ASP and resumed session of the 8th ASP leading into Kampala. And the Obama administration team was present for these, but of course the definition had already been done, so they missed the key formative time. I'll just say a couple things about the definition. It draws from very historic roots, so the goal was not to reinvent the wheel. When you start out in 8 bis para 1, the verbs, the planning, preparation, initiation, or execution, these are essentially drawn from the London Nuremberg Charter. When we define the act of aggression in paragraph 2, we're quoting 2.4 of the UN Charter, and we go on to GA Resolution 3314 for a list of illustrative acts. So it was decided, let's not reinvent the wheel, but draw on these sources. The crime only is a leadership crime 8 bis para 1 applies to a person in a position effectively to exercise control over or to direct the political or military action of a state. 2, of an act of aggression, see para 2, which by its character, gravity, and scale constitutes a manifest charter violation. So there was a lot of discussion. Do we want a flagrant charter violation, manifest, any charter violation? We chose manifest to really mean a very, very clear situation. So quite a high threshold. By its character, gravity, and scale cut out de minimis incursions. There's ICJ case law, for instance, saying what is below the threshold of armed attack in Article 51. This would be relevant jurisprudence for this exclusion of de minimis incursions. It also excludes interventions which are not manifest by their character, and this is where humanitarian intervention is excluded. Just one last word on jurisdiction. I think it was already referenced. The U.S. is, as a non-state party, is completely excluded. So note, this is a different jurisdictional regime than the rest of the Rome Statute. The rest of the Rome Statute, U.S. national, is in Afghanistan. There is jurisdiction. Crime of aggression, different regime, U.S. completely excluded. So U.S. concerns, when they have been raised, have been kind of making them kind of on behalf of allies, thinking, will we have difficulty getting coalitions? But the U.S. is not directly at all impacted. I know this was one of the goals of the U.S. negotiating team. Just ponder, it also exempted Russia and China, okay? State parties, unfortunately, also have an opt-out. So once these non-state parties got this, tremendous, we're just out of this, state parties said, we want to be able to opt out. So they can send a declaration and get out of jurisdiction. This creates a very weak jurisdictional regime. There's currently a dispute how we read the jurisdictional regime. For the sake of time, a few in the room will know this is how do we read 121.5 second sentence? Do we take the literal reading or not? So this is, I think, being resolved. There's a facilitation process on this. The Liechtenstein majority reading would say that the aggressor or victim has to be a state party. What was UK reading, but I think post-Brexit is the French reading, is the aggressor has to ratify, which frankly we never agreed on. But anyway, they're working this out through a facilitation process, which I expect to be concluded as we lead into 2017. But this means jurisdiction is super, super restrictive. So, how is this crime of aggression, if it activates, going to impact the ICC? Really not very much at all. We've got this very high threshold for the crime to be triggered, and then jurisdiction. So if you need the aggressor and the victim, or the aggressor or the victim to ratify, look who's ratified the amendment. It's mainly Europe. We don't have problems with Liechtenstein invading Switzerland. Unfortunately, for those who support this, it's not a lot of jurisdiction. So for those who say, oh, it's going to overwhelm this poor court, no, hardly. It's just not. Example, if Palestine thought it was going to get Israel, no, Israel, non-state party completely exempt from the crime of aggression jurisdiction. There's not. It's still important. I think this completes the Rome Statute. It completes the legacy of Nuremberg. It's an important jurisprudential statement. It advances the rule of law, but it's got a lot of carve-outs and limitations. So it's not going to suddenly overwhelm the court at all.
And the states parties will take up the question of whether to bring it online at their December meeting. Okay, let me open this for questions. If you could come to the microphones and say who you are. Let's keep the questions short, and I would ask the panelists to be very brief in answering them as well.
My name is Carl Mintz. I'm a retired congressional employee, and my question is, what's the IC doing on environmental crimes?
Who wants to take a crack at that? Okay.
I think in the terms that you meet, sir, the court is not taking up environmental crimes in the sense that the Environmental Protection Agency deals on specific issues, for example, and there is no crime on the environment as such in the Rome Statute. That's not, however, quite the end of the story. It is a war crime for an occupying power or armies to destroy the environment as a action or strategy of war. It is also a crime of genocide to destroy the environment, the habitat of a particular group of people, with the objection of doing that in order to destroy them or at least to displace them. So we don't have crimes of the environment in the sense of trying to protect the environment as it is. We do have two sets of crimes that involve the environment in specific situations.
Thank you. Any other questions? Yes, please do come up to the microphone and identify yourself.
My name is Marie-Joseph Aissi. I'm visiting researcher at the Georgetown Law. I have a question across what Professor Jen Stromstead said about the deterrence of the action of the ICC, and on the one hand, and on the other one, what Mr. Charles Jadot also said about the sequencing, the sequencing of the action of the ICC, which can jeopardize sometimes peace process and so on. Do we have example of situation where the action of the ICC had negative impact on peace process or a reconciliation process on the one hand, and on the other hand, do we have also situation where the action of the ICC positively contributed to achieve a peace agreement? The second question is about the opportunity of opening and or initiate a preliminary investigation. I would like Professor Jen Stromstead maybe to elaborate a bit more about the opportunity by the ICC to open or initiate an preliminary investigation. Thank you.
Just on your preliminary examination, is it a specific country or just a general question about its catalyzing effect?
General, because I have some example, for example, Burundi and so on. So because I went to Burundi on mission,
Right.
and we were trying to negotiate between the government and the other part, the NGOs and the political other political parties and so on. And when you receive, it can be unpleasant when you receive a text saying that the ICC has decided to open or to warn about a preliminary investigation, and you came out of the room and you say, wow, this is not something very positive for the peace talk. So, but yes, in general, thank you.
Okay, well, those are very good and very complex questions, and let me just say a few words, and Charles.
And then Charles,
yeah,
we'll
Charles
ask
should
you to
say.
take the last word, and
Yes,
then we will
and,
adjourn
or
after that.
Richard too. Richard has a lot to say on these issues. Marie-Joseph, as people may know, is with the High Commissioner for Human Rights office in Geneva and has spent a lot of time in Burundi and other places, so very much appreciate the knowledge that elicits your questions. On preliminary examinations, I think that there are examples where the hovering effect, where the prosecutor opening a preliminary examination and for many, many years looking over a situation, encouraging greater attention to justice issues, has made an impact. I think in the case of Colombia, where there's been a preliminary examination for so many years, and the attention of the ICC to the situation, I think did contribute to making sure that there were meaningful attempts domestically to include justice and accountability provisions as part of the peace agreement. As you know, they're somewhat innovative. They provide for alternative sentences with restrictions on liberty, but not incarceration in certain instances, although they also make clear there can be no amnesty for atrocity crimes. So I think that's actually a positive example where the ongoing involvement over many, many years of the ICC in examining that situation has helped to spur and prod a peace process, challenging though it may be, and it's still a work in progress, to somehow figure out a way to bring together the pursuit of peace with the pursuit of justice. I think in a case like Burundi, as you note, it's terrifically difficult because Burundi has refused to let ICC investigators in. It's refused to let human rights monitors in. It said it's going to remove itself from the ICC. So it's sort of a counterexample where a country really holds its arm against the monitoring not only of the ICC but of the international community more broadly. And yet I think it's critical to make clear to the authorities there that the atrocities being committed are being documented, evidence is being gathered, and that there could be and hopefully would be accountability someday for those kinds of crimes as a way to try to induce some degree of change in the behavior, although it's very tough, as you note, in a situation like that.
If other panelists have literally 2 sentences to add, because then we really are out of time.
Okay, thank you very much. Great questions. Just very quickly, a couple of points. One, I think of, in addition to the examples that Jane gave, also of the role of the ICC in respect of Guinea. I think the deliberative approach that the OTP has taken in respect of dealing with the stadium killings is a great example of a circumstance where the court could be very effective, just hanging on to the threat of investigations and involvement of the court could be perhaps even more effective, because ultimately, as Stephen was saying earlier, and I think many people in the room will support this, the heavy lifting in terms of accountability would have to take place at the national level. We all love for the ICC to get involved. Clearly, the ICC should focus on those bearing greatest responsibility, those in leadership positions, but the run-of-the-mill guys, the middle-level perpetrators and the lower-level perpetrators, and in some conflicts, thousands of them, not the case in Guinea, but in most conflicts, thousands of them, the work would have to be done at the national level. So in my view, taking the long term, especially when you think about the funding limitations and what have you, the court could be more effective just hanging on to the threat of prosecutions and then working with that system. They were doing a little bit of that work in the Côte d'Ivoire as well, with some development assistance from the European Union, states and so on, trying to build some domestic capacity, even as they talked about alternatives. So that could be a great example of an instance where there's positive result coming out of. I mean, Guinea will have to go through and prosecute in fair trials that we all can then review for us to say, yes, it was a success, but I think it's an encouraging sign for us to see from the court. The second point, and this is going to be my final point, this actually ties into both comments that have been made by John, but the 2 Johns on the panel, but also David Sheffer earlier. One of the key things that I find significant about the U.S., I'm less interested in the United States becoming a party, but more interested in the role of the U.S. as a global leader. The U.S. is a powerful country with incredible supportive capacity for countries, and the ICC in particular. The U.S. could put its diplomatic weight behind the ICC, even if the U.S. is under investigations potentially. John was mentioning the Afghanistan scenario. This is why we have complementarity. David reminded us that this has happened before in respect of the ICTY. The U.S. is still here. In fact, it will be one of the model countries with the capacity to discharge its complementarity obligations. So I wouldn't be worried about an investigation vis-a-vis the U.S. I would want the U.S. to turn that around, take it to the next level, and play that global leadership role that we saw after the lessons of the first Bush administration into the second administration, realizing that there's incredible long-term interest, foreign policy of the U.S., interest that could be taken out of the U.S. being supportive towards the court, whether it's at the UN Security Council, whether it's rewards for justice that Jane talked about earlier, that would help turn people over to the court, so that we will have a global criminal justice system that's effective. I'll leave it at that point for now. Thank you.
John Bellinger, you had something that you wanted to add.
I'll just say on that, I agree with Charles on that. I would like to see the United States respond that way. I would certainly be making those arguments if I were inside the government, but we have to deal with the administration that we have, not the administration that we wish we had. And honestly, I'm a chronic pragmatist. That's the right answer, Charles, but I worry that you're going to get a different answer if you provoke the Trump administration. Richard may have last word, but I can't help but provide a sort of a 3-sentence response to Jennifer on aggression for the benefit of all the students, because she made the sort of the passionate argument why the court should take on aggression. Just so you know, the U.S. government in the Obama administration is strongly opposed to that. You should read the law review article written by my successor, Harold Coe, a leading human rights lawyer and a member of my former office, Todd Buchwald, on why adding the crime of aggression to the court's current workload would be a bad idea. The law review article is in the American Journal of International Law. It is mind-numbingly complex. And to save you the trouble, I spent a weekend last year trying to understand it and summarized it for you all at Lawfare. And so if you want to understand why the United States in the Obama administration felt that the crime of aggression should not be added to the court, take a look at either the long version or the short version.
Okay, well, we are out of time. I think it is only appropriate, since this is a law school, that we... Oh, okay, I'm sorry.
Thank you. Two different issues. First, the peace and justice one that the colleague from the Office of the High Commissioner raised. I think 3 outstanding points. One, justice has proven to be an essential component of a lasting and durable peace. 2, the fact of the matter is when there is tension between these 2 important objectives, the tension can be managed. And lastly, when it comes to justice as a threat to peace, I think the concerns are greatly overstated. And with sadness, I refer us all to the situation of Sudan and South Sudan, when at the time of the Omar al-Bashir arrest warrant, it was predicted that arrest warrant would destroy Sudan's comprehensive peace accord that could lead to a peaceful succession of South Sudan. No such thing happened. The last point I want to make in regard to the difficult issue that we've been talking about in regard to the Trump administration. First and foremost, I think it's imperative for civil society to do all we can to protect the independence and impartiality of the Office of the Prosecutor, to give her the space that she needs to make the difficult decisions she has to make in applying the Rome Statute to the facts. At the same time, I think it is likely that the Trump administration will go on the offensive against the court for any of the reasons that have been cited. And I say this with a degree of humbleness, real humility. I think lessons learned from past encounters in trying to wreck this court leads to the lesson that John's former boss drew in 2006. These anti-justice and anti-ICC policies lead to the U.S. government shooting itself in the foot. I think the greatest loser here will be the credibility, as Charles was suggesting, of the United States government when it comes to championing justice for victims of the world's most serious crimes.
And so we will hope for a tweet that says ICC, good. So I would like to thank our panelists for just a terrifically illuminating discussion, and I would like to thank all of you. So please join me in giving a round of applause.